We're live now. Okay, good afternoon, everyone. We are back for the ever exciting week of crossover, and we have a lot of bills to get through. This is the Senate Government Operations Committee on Tuesday, March 14th. We're going to start with S17, a bill about sheriff reforms, and we have a new draft. 3.3, we're going to have our legislative council attorney, Tim Devlin, take us through the changes since the previous draft, basically. So take it away, Tim.
Thank you very much, Chair Hardy. Again, for the record, my name is Tim Devlin, Legislative Counsel. The changes since the last version that this committee looked at, which is version 2, this is actually a version or draft 3.3, dated today at 11 a.m. for your reference. The changes since the last iteration have been highlighted for reference and ease of finding them on paper. And I'll just start by quickly summarizing them. There's 5 main topics, and then I'll return to the highlighted portions throughout the bill. And we can either read through them line by line or at whatever pace.
Okay.
So again, just taking it from high level, 5 changes we see in this new version are: 1, this draft removes sections pertaining to the reorganization of the Department of State's attorneys and sheriffs. 2, this introduces a conflict of interest requirement for sheriffs and sheriff's deputies. 3, this reworks the provisions relating to sheriffs providing law enforcement and security services to county and state courthouses. A, now setting a rate of pay for statewide contracts between sheriffs and the judiciary, and B, requiring sheriffs to provide these services beginning on July 1st, 2024. The 4th point of revision in this draft is draft reworks the provisions pertaining to assisting domestic violence survivors to A, require assistance by sheriffs, and B, prohibit collection of fees for this service. This may sound familiar, but it differs, and we'll go into that in more detail later on. The 5th change is that this draft reworks the session law regarding the Sheriff Oversight Report, and now creates a Sheriff's Department's Oversight Task Force composed of various stakeholders to issue a report instead of the Department for State's Attorneys and Sheriffs, I believe it was before. So turning to the language itself, the first change you will see highlighted is on page 5. And this is the new section 4. And this pertains to conflict of interest and the appearance of conflict of interest. Just to briefly summarize here. The subsection is laid out in defining what is a conflict of interest, then a requirement to avoid those conflicts of interest, a provision in C to approve by majority vote of the Sheriff's Executive Committee some conflicts of interest if the situation sees fit. D, it's clear that the statute puts down a floor for what is acceptable, and then the Department of State's Attorneys and Sheriffs may impose additional requirements for conflicts of interest on top of that statutory language you see here. And then E, a provision pertaining to information that does not necessarily have to be released in these situations. Madam Chair, would you like me to read through this line by line?
What is the committee's preference? Would you like Tim to read through it, or can you read it?
Well, I've read it, and I don't understand it, so.
Okay, why don't you take us through a little bit more in depth?
Absolutely. So section 4 amends Title 24 of VSA section 314. It actually adds a new section 314, which will read titled Conflict of Interest, so we call it Appearance of Conflict of Interest. Subsection A, starting on line 17, reads, as used in this section, conflict of interest means an interest of a sheriff or a deputy sheriff that is in conflict with the proper discharge of the sheriff's or deputy sheriff's official duties due to a significant personal or financial interest of the sheriff or deputy sheriff, of a person within the sheriff's or deputy's sheriff's immediate family, of the sheriff's or deputy sheriff's business associate, or of an organization of which the sheriff or deputy sheriff is affiliated. Conflict of interest does not include any interest that is not greater than that of any other persons generally affected by the outcomes of the matter. Subsection B, the sheriff or deputy sheriff shall avoid any conflict of interest or the appearance of a conflict of interest, except as otherwise provided in subsection C, so it's a typo there. When confronted with a conflict of interest or an appearance of a conflict of interest, a sheriff or deputy sheriff shall disclose the conflict of interest to the sheriff's executive committee, recuse themselves of the matter, and not take any further action on the matter. Subsection C, a conflict of interest may be approved by the majority vote of the sheriff's executive committee only if, the material facts of the conflict of interest are disclosed or known to the sheriff's executive committee. If a conflict of interest is approved, the sheriff or deputy sheriff may then act on the matter at issue. Standard operating procedures manual or policy manual created by the Department of State's Attorneys and Sheriffs may impose additional requirements relating to conflicts of interest on sheriffs and deputy sheriffs. Nothing in this section shall require a sheriff or deputy sheriff to disclose confidential information that's
So Tim, can you explain why this appeared in the draft? Because this was, ahead.
Sure, I can, I think it'd be appropriate for me to explain how the language relates to similar conflicts of interest. But as far as the intent, though, I don't know if I should be speaking to that necessarily.
Okay, go ahead. Say what you were going to say, and then I.
Sure. So this mimics the conflict of interest information that our policy that was put into statute, I believe it was last session, maybe the session prior, for state employees, including elected officials, found in Title III. It also borrows from some of the language for conflicts of interest as they appear in statutes for corporate management. And so, but largely from Title III as it applies to state employees and elected officials already. Similar use of conflict of information or interest, that is the definition of section A, as it pertains to those which would interfere with discharge of duties. Also an emphasis on not only financial interests, which is pretty typical for conflicts of interest, but also the parties of which those interests can be, in which the sheriff or deputy sheriff is associated with, the expanding those conflicts too. So the person themselves, family, business associates, and important issue here that is different from other iterations of conflict of interest laws throughout the statutes are pointing out if there's conflict of interest between the sheriff and pertaining to an organization of which the sheriff or deputy sheriff may be affiliated with as well. From there, the rest of the language is very similar to how it appears in Title III, and maybe I'll just pause there and see if there's any more specific.
Thank you. So line 6, or maybe 5 and 6. So the sheriff or deputy sheriff shall avoid any conflict of interest or the appearance of a conflict of interest. So was the appearance of a conflict of interest also borrowed from?
Yes.
Okay, so that is a standard that we expect of other elected folks.
Continuing employees, yes.
Okay,
That's
that's,
what I was going to say, and non-elected.
and
It's in our code of ethics.
Yeah.
This is from the work we did in this committee.
So this, I mean, so just where this language came from, why it appeared in the bill, because it was not specifically requested, but it was suggested by legislative council in order to address the issue with sheriff's department creating a sort of
yes,
shadow
that's right.
kind of nonprofit organization and how that would be a conflict of interest. So this was
got you.
suggested to get at that situation.
That makes sense. My only concern was that the conflict of interest, I feel like it's a pretty provable thing. Appearance of conflict of interest is
Mhm.
It's much broader and it's kind of harder to nail down. But if it's a standard that's applied across other, like it's on.
And it's embedded in our code of ethics and defined in the code of ethics, I believe.
Yes, and I can provide the specific section or citation.
So we,
Madam Chair.
Yeah, go ahead.
so because it's defined in our code of ethics, we don't need to define it again here. It's referred to where it is statutory, right?
Well, in the existing code of ethics, in Title III pertains to a different grouping of individuals, and cross titles, you probably want to define it. Again, we could insert a cross reference so that if one changes, this could, but I would say that this language was modeled on Title III language that exists already, not an exact carbon
Right.
copy of it. So there's enough variance already kind of tailoring it to this this group of individuals here that I don't know if you'd prefer a cross-reference to that instead. I can take a look at that and see exactly how that may or may not be a better fit versus the definition imposed right here.
Okay,
Sorry.
okay. Yeah, if you could look into that, and we can come back to this since it's new language and whether this meets our needs or what.
And I'm
Go ahead.
happy to provide you statutory citation right now. That's 3 VSA 1201,
Okay,
where you
thank
find
you.
definitions for the state code of ethics.
Senator Norris.
Yeah. Timmy, under V on line 5, it says a sheriff or deputy sheriff, and I heard something, it says state employees, whatever else.
Mhm.
Does this just refer to the sheriff and the state deputies?
As written, this would be sheriff, deputy sheriff, and I believe, if I understand your question correctly, some of the deputies are state funded versus departmental funded.
They're not state funded, that are.
So this would apply to anybody with a title, deputy sheriff, regardless of funding source.
Because I was curious as to, when I was talking about the definitions, and this doesn't, how does this differ from, and now I can look it up and find out under 1201, obviously.
Are there other questions on this section? Senator Clarkson.
I have one, and I just can't remember if hiring practices, hiring family, hiring, yeah, that's a conflict. That's considered a conflict.
Yes, that's it.
Right, my question, I just wanted to clarify that. My question is on lines 14 and 15. When you give the sheriff's executive committee the power, they may act on the matter at issue. Given the statutory, constitutional restraints of this job, what may they act on? What could they actually do? What could the sheriff's executive committee actually do?
So in the event where there's a conflict of interest apparent in the duties of a sheriff in particular as an elected constitutional officer, and then if I understand the hypothetical correctly, if the executive committee were to approve or not approve that conflict of interest and the sheriff were to, let's say they didn't approve it and continue acting despite a not approved conflict of interest, what would be the recourse? Is that the question?
Well,
Or
could they, I mean, they can't remove a sheriff. I mean, we know that constitutionally, but they could censure them. They could, what are, and they could act on this issue. That means what does that, I mean, I assume with the deputy sheriff, it means they could be censured. They could be fired or whatever, but I just would love to know what the range of action.
Sure. And actually, as written, it was our office's intent to say, understand that sentence in a different manner.
Oh, okay.
Really, if a conflict of interest is approved, the sheriff or deputy may then act on the matter at issue. That is in contrast to being prohibited from acting on a matter where there is a contract or conflict of interest existing. So if they're to encounter the appearance of conflict of interest or an actual conflict of interest, under the first sentence on 5 and B, they should avoid any, and then, lines 8 would be to, sorry, 7, when confronted with a conflict of interest or appearance of conflict of interest, the sheriff or deputy sheriff shall disclose the conflict of interest, then recuse themselves from the matter and take no further action on the matter. So that's to be tied to that last sentence in 3 there. So if the conflict is approved by the sheriff's executive committee, then that would kind of unfreeze the conduct of the sheriff's deputy and allow them to continue to take action on that situation, whatever the facts of the case, not case, but situation might be. Sorry, I hope that provides some clarity there. It wasn't really intended to say that the sheriff or deputy sheriff is making calls on the appropriateness of conflict of interest once it's been disclosed. Really, that's reserved to the sheriff's executive committee to either okay or not. And in the instance where it's okay, then the sheriff or deputy sheriff whose conduct is frozen is then allowed to continue.
And just a follow-up, given that we're removing the changes that we had made to the Department of State's Attorneys and Sheriffs, the Sheriff's Executive Committee already existed and exists now.
Yes.
Right. Exactly. I just wanted to clarify that.
So I was just looking up the 3 VSA 1202 with the applicability of the state code of ethics. It's all individuals elected or appointed to serve as officers of the state.
Right.
Are sheriffs considered officers of the state? State in capital letters, but.
Right. That's a good question. I'd have to take a look at those definitions because I know that they're a little bit, aside from, they're not necessarily as commonly understood. I think there's, what is it? Public official is not exactly what we think of public official. That doesn't apply to municipalities, for example. It's only state level folks. So I have to take a closer look at that answer.
I mean, it does look like it's mostly state people, not local people, which the sheriff would be.
Right.
So
And-
this would take a chunk of the state code of ethics and make it applicable to sheriffs, kind of.
Which are regional kind of.
Yeah.
Counties.
Yes.
Yeah.
And I believe that the code of ethics existing in Title III doesn't apply to political subdivisions of the state.
Right, exactly. It doesn't look like
Counties.
it, yeah.
I can certainly.
Yeah, if you can verify that, just to make sure, but that's what my read of this would be, taking part of the code of ethics and applying it to sheriffs, basically.
And one other quick point, I just want to say that the Title III definitions actually don't include the definition for conflict of interest. That's in 1203, not 1201.
Oh,
And
okay.
there's, the definitions are found throughout subchapter 1. there.
Okay.
So,
One
And
more,
just
go
riff
ahead.
off your idea of.
Yeah.
So the county, the other county employees are the assistant judges. They are covered in the code of ethics through the judiciary. They are covered, I believe, under judiciary's code of ethics.
yes, that sounds right.
So, I mean, there is already a precedent is all I guess I'm trying to say
Mhm.
on the county level for the people being covered.
And the state's attorney is covered through the judiciary?
Yeah, and through their own, and through
Yes, through the bar.
the bar and through their oath of office as lawyers.
So this is sort of like one space that just because of the way things are written, kind of snuck through and didn't get covered.
I think that's correct. I think they're the only county employees that aren't.
Well, Tim will get the answers to us on this, so we're not speculating.
It's
But
fun to speculate.
well, it's not helpful at the moment, but let's keep going, Tim.
Yes. Returning to the page, let's see. So moving on to the next area of change. These section numbers have been renumbered due to the omission of the what were these sections pertaining to the restructuring of DSAS. But moving on, we'll see rephrased language pertaining, let's see, we're at the bottom of page 8, and the next series of highlights.
Yeah.
And this gets to the contracting for security services, law enforcement services at county and state courthouses. And again, this is in two different parts, two different sections of law, and so I'll just kind of point it out the second part when we get to them. It's below under sheriff's duties. The first part appears under contracting. Specifically amends section 5, amends Title 24 VSA section 291A, subsection. And I'd be happy to read through this.
Go ahead, yeah.
It's the simplest way to explain it. Starting on line 14, subsection F reads, an agreement or contract for sheriff's departments to provide law enforcement security services to county and state courthouses shall be subject to a single statewide contracted rate of pay for such services over all county and state courthouses. The rate of pay shall be $51 per hour beginning on July 1st, 2024, and shall be increased annually thereafter by 2%, which shall be subject to the availability of funds appropriate for this purpose. Pause there.
Senator Yoski.
Is this essentially setting up sort of a new group of sheriffs? And the reason I ask this is because last year we gave bargaining capacity to the transport sheriffs that were doing some of this work. And if this is creating a new group, it would make sense to me that it would also be a bargaining group.
So it's not. That is an option to create sort of court security sheriffs, sort of like transport sheriffs. But this was the sort of, we tasked the judiciary and the sheriffs to come together and create a language that they could agree on. And this is where they're at. Creating new state deputies, I think, would be a bigger task and might be something we could consider in the future. But this wouldn't do that right now. It would just say that this is what the contract would be. And then there's later language that requires them to do the duty.
Okay.
Is that accurate?
Yes,
You
yes.
Feel free to correct me.
I think it'd be useful just to skip down to the top of page 10 to look at the second half of the sheriff's language. And then we'll return to that. I'm breaking our topic here. So this is under sheriff's duties, Title 24 VSA.
So you're just.
Page 10, yeah, he's
What
gonna
happened?
come back to it.
Okay,
This is
got it.
just related.
Section 7 will amend Title 24 VSA, Section 293, subsection E. And this creates a duty for sheriffs to provide those services we're just discussing. Specifically, it reads, starting on line 1, subsection E, the sheriff shall provide a minimum of 1 deputy sheriff certified as law enforcement officer in accordance with 20 VSA, section 2358, for law enforcement and security services for each county and state courthouse within the sheriff's county jurisdiction in accordance with section 291A of this title. And 3 things I just want to note. First citation, 20 VSA 2358, that pertains to the requirements for law enforcement officers under the statutory provisions for the Criminal Justice Council. The second citation, 29A or 291A, that's the section we're just looking at for contracts. And then this is in its own section because it'll have a later effective date, being July 1st, 2024, as the rest of the bill is effective upon passage.
Okay, Senator Watson.
Yeah, thank you. So I'm back on page 8, line 18. The pay will be increased annually thereafter by 2%. I just want to express that makes me nervous to take it as a fixed value. I mean, that has been inflation for the past many years, except for the last 2 years, when it's been more. Curious about the thoughts around picking 2%, wondering if there's the option to say to increase or decrease with COLA, or not decrease, to increase with COLA up to 8%, but no less than 0%.
So the language that the courts and the sheriffs came up with would have said 2% or tied it to some kind of pay raise for state employees. And the reason that that is not in here is twofold. One, there's not a sort of standard pay raise for state employees. It depends on lots of different factors. So having it tied to a standard pay raise was complicated. 2, the way that I think about this is that this is not to pay an employee, this is to pay a contract. So they are contracting for $51 an hour of services, not $51 an hour of a person's salary. So that could include overhead, that could include transportation and fuel to get the sheriff there. It could include all those other things. The $51 is just the hourly rate for that contract. So tying it to a cost of living increase does not make sense in terms of the cost of the contract going up.
That's a useful clarification, because
Yeah.
otherwise you do think this.
Yeah, it's not meant to be an individual. This is meant to be an hourly rate of service. And how much does that hourly rate of service cost? Not how much does somebody get paid an hour to do this thing? Does that make sense?
It does. I also see like, inflation is affecting the price of everything, and what if inflation is,
So we could tie it to like CPI of some kind.
Yeah, COLA
you
may
know,
not.
COLA's more of a
That's
salary kind of
yeah.
thing, but we could tie it to some kind of
Yeah.
CPI measure. This is also something that will make this bill go to appropriations,
yeah.
and they will certainly take a look at this. Do you have a suggestion? I see you, Senator Clarkson. Senator Watson, do you have a suggestion for?
Well, I would say to increase with CPI and then put boundaries around it, no less than 0% and up to 8%.
8% is a huge increase
I
in,
know.
yeah, so that, I mean,
Well-
that's why I think the 2% is more than
doable.
fair,
Yeah.
frankly. If we did it to CPI, then there's also like a regional New England
Mhm.
CPI that is more specific, and we can ask JFO about that, but.
Yeah.
Yeah,
Whatever the window makes sense.
I just
Doesn't have
think
to be
that it's an 8% increase in a contract rate is pretty
Yeah.
significant, so, Senator Clarkson.
Before we do that, I would really like to find out from JFO and or from BGS what a standard increase is built in for contracts, not for individuals.
Yes.
I think we shouldn't just, I'd get some science behind it.
Yeah, so this language is shared with BGS so that they can take a look at it and give us their feedback too. So they might have some feedback.
Yeah.
Did you share it with them, or will you? I think
Is
you
there a
will.
question about we can't?
Yes, I think I responded, but who knows? Maybe I just thought in my head that I responded to you. Okay, so we'll come back to that and see what makes sense there.
Quickly, one question.
Yeah, Senator Norris, go ahead.
Positions we looking at?
There are 23 courthouses throughout the state. Not every county has 2 courthouses. About half have a county courthouse and a state courthouse.
Wait, I'm sorry.
Oh, gosh.
When Terry's up for, she can answer your question when she's on the
Oh, it's fine.
witness stand. I just don't want to have 2 witnesses talking. No, you're fine.
Whatever.
Yeah. That's why she's here, to talk to this. So, why don't you finish, Tim, and then we'll.
The next, sorry, so we had skipped over so we'll return to page 9.
Thank you.
And this pertains to duties of sheriffs, specifically the act of accompanying domestic violence survivors to pick up a retrieval of personal belongings and fees associated with that. This has been reworked and was going to go into a different section, but now is returned to the particular statutory area for sheriff's duties. Specifically, Section 6 amends Title 24 of VSA, Section 293. And we'll see the pertinent highlights in subsection D, which now reads, starting on line 12, sheriff's departments shall have a duty to assist in the retrieval of personal belongings from the residence of an individual who has relief from abuse order pursuant to 15 VSA 1103 and that individual's dependents. Sheriff's departments, when assisting in the retrieval of personal belongings from the residence of an individual who has relief from abuse order pursuant to 15 VSA 1103, or that individual's dependents, shall not seek a fee from the individual or the individual's dependents being assisted or any representative of that person. pause there.
And this, you might recall, we asked the Sheriff's Association and the Network Against Sexual and Domestic Violence to come up with some, agreed upon language. They were not able to do that. So this reflects what what I heard from the committee, which is we don't want individuals to be charged for this service, and that it's important that they have the assistance of law enforcement if to do this. And so this would just say sheriffs need to do it and they can't charge people from it. So failing any kind of agreement, this was the best we could do.
I'm sorry that they weren't able to do it.
So I have a lot of questions on this one here. I don't know who to ask.
No, go ahead, Senator Norris.
So is this now saying that sheriffs shall have a duty to assist anywhere in the state of Vermont, even if you have your own municipal police department?
So if there's, if my understanding is if there's a relief from abuse order and a victim needs to go get their belongings, law enforcement in fact, sometimes the state police do it, sometimes municipal police do it, sometimes sheriffs do it. If sheriffs are asked to do it, then this would require that they do it and require that they not pay.
So this says shall, so this means that the sheriffs are going to be responsible for retrieving any and all personal property. My question is, I'll ask Judge Zone when it comes time, because we don't know what you're retrieving, so on and so forth. Basically, when you get there, they want this, and this, and they say, you can't have this, and this, that's a civil matter, and it's not as easy as putting words to a piece of paper, shall we say. But anyway, I'll ask Judge Zone. Is he going to testify?
He is not testifying.
Oh, I'm sorry.
Terry's here to testify
Oh, wait,
for the
Terry.
courts. And they were not, I don't think she's prepared to testify in this provision. This was similar to the language that was originally that was first put in the bill after we heard from the network, I believe, Tim, right?
Yes, it's.
Yeah. And then, so they couldn't reach agreement on changing the language, so we went back to the language that was originally suggested by the network. And we certainly can tweak it, but I think this is where we're at this point. And if you have, do you have suggestions, Senator Norris, about tweaking it?
The problem is that sheriffs have their state paid deputies and a group of per diem or whatever else, but they're assigned to specific duties. Now, if in fact, somebody needs to retrieve their property, and we can't expect an entity to go out and do just that and not, are they now supposed to pay their employees for going up and doing this when it's out of their general fund? When how do you expect this to work, I guess is my question.
Who's paying for it?
Well, the sheriff's department has a budget that they are supposed to use for providing public safety services to communities, just like municipal police, just like state police. Neither of the
They don't
other.
have a budget. They're entrepreneurs. They go out and they solicit contracts and so on and so forth.
I
They have
think
a general
arguably
fund.
that's one of the problems. And that's what we're trying to get away from.
Yeah.
Senator White.
Thank you, Chair Hardy. So the way I understand the language is that if there's a sheriff that says, you know what, actually, it's not affordable for me to help domestic violence survivors remove property from the home of a place where they are potentially at risk of violence. If they say, not in the budget for us to do that, fine, you can't charge them. And the way the language reads is then you can have the local municipal public safety or the state police, if necessary, be the responder. So yeah, they're losing out on a possible income stream, that's true, but they're not going to be unserved, the people who are experiencing the need of that service. Is that correct? In the way the language is written?
I would characterize this as sheriffs would be a backstop.
Great.
If
Yes.
requested, and then if the assistance were to be provided, sheriffs and departments would not be able to seek any sort of fee for that service.
Yeah.
So,
Yeah, and I guess what I heard was really compelling from the Vermont Voices for victims because it sounds like it's extremely traumatic to have to be paying for that fee. And while I understand the budgetary question, I think if a sheriff truly cannot afford to cover the service, they shouldn't be charging victims because it sets up a false choice for them where they're in a situation where suddenly, oh, I have to pay a fee? I didn't know I had to pay a fee. You're telling me that I might not get protection? So I think it actually sets up a much clearer relationship with the sheriff department and what their services are, because they can make an informed choice rather than, I'm sure, many situations where someone who needs this service is not thinking that they're likely to get charged for it, which is why I was so surprised when we heard from Vermont Voices that folks were.
Senator Clarkson.
So many sheriffs have contracts for a variety of things in every town, in the towns they cover. Some of it's just for traffic control and traffic enforcement. Some of it is actually all law enforcement within that town. Bob, are you saying that, you know, if the first responders we're expecting are the law enforcement, the local law enforcement for that town would do it, then maybe the state police, if that's where are you saying you'd rather have guardrails put around this that would be for the towns that the sheriff's contract with?
And reading the bill, it just simply says sheriff's department shall have a duty to assist. And I'm saying, does that mean they're now responsible for the entire state of Vermont? I mean,
No, for their county, they're not.
it doesn't say that.
I mean, I'd be amenable if we put in for their specific county, if that would clear up confusion. Because I think that is true. Yes, I wouldn't want Windsor County Sheriff to think he's responsible for a Rutland County person, but
Yeah, I mean, I think it's kind of implied that they only have.
Their jurisdiction.
But they have statewide jurisdiction, but that they're only covering duties for their county. But if that would make people feel more comfortable with the language, that seems like a reasonable thing. It's just, or.
They're only responsible for their jurisdiction, so I would assume that.
Well, technically sheriffs and most law enforcement officers in our state have statewide jurisdiction. So and that's because they might have to transport people over
Oh,
their
that's right.
county lines, or because they might have to go to a court case in another county or something.
Right.
So that is saying their jurisdiction is statewide.
Right. So if we limited it to the county, that.
Does that make sense?
Yes.
Okay.
Senator Bielski.
I'm perfectly fine with that. I just want a clarification. So if we put the language and limit it to the sheriff's county, would that prevent a sheriff from assisting in another county? You know, I just think of some of our close towns where it might actually be easiest for me, you know, as the Chittenden County Sheriff to, you know, run into, I'm trying to think of into like the edge of Washington County, because I happen to be closest there. So I appreciate making the language so it says that they don't have to, but I don't want to make it the language say they can't help in another county.
Yeah, that's a fair point.
I
So
would
go ahead.
interpret this to say that they would, with that amended language, they would have a duty to respond in their own county, but there would be nothing prohibiting them from responding across county lines.
Requesting an agency assist, they can respond across county lines or.
I just want to make sure that we thread that needle, because I know there are times when it might be actually that it is easiest for someone from another county on the edge there to help out.
that's a good point.
But that part.
Wait, can we?
I
I don't want to get out of control here. What did you say, Tim?
Oh, sure. So as written, or as we would like to add language about responding, having a duty to respond to instances within their county, that creates a duty to respond to everything within the county, but it would also permit responsibility.
Okay, perfect, okay. So does that make you comfortable? Okay.
Do that.
And Senator Norris, what were you saying? I
sorry.
missed what you were saying. Are you just talking about cookies or?
Okay, we're good.
Okay. Just making sure it was, and Senator Clarkson, did you make your point?
It's just that those orders, yeah, I think this is fine too. I
Okay.
think your solution's fine. It's just, those orders are obviously from the county courthouse, from the.
Yeah.
Well, they aren't always, are they? They could be from another, yes, okay, I take it back.
But if this gives them the flexibility that they were required to do it if they're requesting their county, but they can assist in outside of the county, then I think we
Right.
threaded the needle, okay? All right. You want to move on?
Sure. So we've already addressed the changes in section 7, top of page 10. So we'll continue down to the bottom of page 10, breaking to 11. And this has, actually, sorry, nope, at the top of page 11, this pertains to Sheriff's Department's Oversight Task Force and report. Again, this creates just a new task force created of stakeholders to look at it versus before. I believe it was a report to be by the Department of State's Attorneys and Sheriffs. So this would create a new task force instead of those. If you'd like, I can read it line by line, but it's established similar to how we kind of statutorily set up other commissions, committees, things of that nature. Perhaps, Madam Chair, would you like me to focus on the membership and
the duties, yeah, that'd be great.
So in section B, membership, we have one member appointed from the Department of State's Attorneys, one member from the Department of Human Resources, one member from the Attorney General's office. It's actually say appointed by, not to be members of it. One member appointed by the Vermont Sheriff's Association, one member appointed by the State Auditor, one member appointed by the Vermont Criminal Justice Council. Sorry, there's a typo here on 7, I apologize. This should read one member appointed by the Vermont Association of County Judges. 8, a member of an organization focused on law enforcement reform who shall be appointed by the Speaker of the House. 9, a member of a different organization focused on the law enforcement reform who shall be appointed by the Senate Committee on Committees. Moving on to powers and duties on the next page 12, subsection C. The Sheriff's Department Oversight Task Force shall consider issues relating to oversight of Sheriff's Departments, including the following, and many of these are the same. We'll just skip to the new ones. Number 2, this is reworded to state increasing efficiency and delivery of public safety services by Sheriff's Departments. Number 6, examining sources of Sheriff's Department's revenue sources, so there's a typo there, in relation to the use of revenues for public safety services provided by Sheriff's Departments and uses not related to public safety services. And 7, reorganizing the Department of State's Attorneys and Sheriffs to better support duties and operations of State's Attorneys and Sheriffs. And other things I'd like to note in the establishment of this committee is the report will be due on November 15th, 2023, this year. That's in subsection E. Subsection F, meetings. The task force will meet first at a time earlier on July 1st, 2023. Then importantly, the task force will sunset, will cease to exist on July 1st, 2024. And then there are some compensation and appropriation percent members of that task force. And the last change would be to the effective dates, which the majority of this act will take effect upon passage, except section 7, which pertains to the duty for sheriffs to provide security contracting force, security services and law enforcement services to state county courthouses. That will become effective on July 1st. 2024.
So this section, Tim and I were just literally this morning trying to work it out. So I think on number 7 at the bottom of page 12 should be oversight and support.
Support to better support the.
To better provide oversight and support of the duties. Okay,
Sorry, you're on line 18.
18 and 19 at the bottom of page 12. And then paragraph 6, and this, the committee can, it's, what I was trying to attempt to get at with this is the frequent thing that we actually just heard about is, sheriff's departments being more like businesses than public service and public safety organizations. And so how can we get at, and a lot of it is a culture change, but it's also a funding change. And there are a bunch of things, there's several things about funding in here, but how do we get at recommendations for changing the culture from a business sort of profit motive to a public safety and public service motive? And that's what I was trying to get at with 6, but it doesn't quite work. So you have suggestions, but Senator Bigos, or questions too. Yeah.
Yeah, just looking at some of the points of the task force and knowing that it is around pay and support, I'm wondering if it makes sense to have an appointee by the state employees union.
On the task
Yeah.
force. How many people are not?
Well, some of the sheriffs are state employees, some of them are not. The sheriffs that we're talking about with the courts are in this bill not, although I think they should be. But I'm looking at things like the compensation structure and levels. And then sort of the reorganization for support. I just wonder if that they should have a member there.
We have the Department of Human Resources, but I mean, what do other people think? And are these the right people, or should any of these people come off? The Attorney's General Office, I'm not sure about whether they're necessary or not, but we were just kind of brainstorming potential, but.
We're going to hear feedback about the composition of this. So
Yes.
I'll wait.
We can hear feedback and see, but I've noted that. Other things, Senator Clarkson?
So I think we can be pretty direct about the issues they're addressing. Or maybe I'll be a little more direct in like 6.
Yeah.
I mean, for me, this task force has the opportunity to really try, examine and set forth a sustainable compensation model for sheriffs. And I don't know if we want to call out eliminating policing for profit, which has been a real concern for many people. But I think sheriffs need a sustainable way to fund themselves and to fund their departments. And it has been a failure of the states. I mean, it's been a failure all the way around for a couple hundred years, figuring that out. So I think we really want to call it out for what we need, which is a sustainable funding model so that sheriffs are compensated appropriately, particularly if we can get them to be established as law enforcement officers, which would be helpful, setting criteria for their eligibility to be sheriff, which we're hopeful to do with the amendment, with the constitutional amendment. But I really think this is what we're trying to do, is get rid of the patchwork of compensation and really have a sustainable model that isn't quite so entrepreneurial.
So number 3 talks specifically about compensation structure. It's already in there. And I would say, I guess I will push back a little bit. Sheriffs in statute, their statutory salary is over $95,000, which is way more than most Vermonters make. It's a lot more than most nonprofit executives make. It is a lot more than education leaders make, and a lot of other people who have equal amounts of duty. And so I just want to push back on that notion that sheriffs are not well paid. They are well compensated, and that the sort of funding model of their department, I think, is problematic and needs to be addressed. But
I wasn't referring to their salary. I mean, I was referring to the patchwork that makes up all their funding and the sustainability of that. And I don't disagree that the sheriff that is a solid salary. But it is, as we heard time and again in the witness chair, their expectation is that they're going to be further compensated through all this patchwork of other things. And I think that's what we really need to get at is, most people know exactly how they're gonna be compensated. It's set forth, it's straightforward. Nothing is straightforward in the sheriff's funding arena, except for
Yeah,
that.
I mean, I don't know how more straightforward it can be than having it literally a line in the state statutes as their compensation. That's what their salary is supposed to be. The whole padding their salary has come about by the way that they have managed the 5% addition. Senator White.
Thank you, Chair Hardy. I guess the only piece that I think is not a part of this that I would like to understand is if there is anything, and maybe it's just implicit in this, but around racial and other, I mean, we require so much data, from my understanding, although we need more from our other more traditional public safety folks. And is that something that, I mean, it's a little parallel to this conversation, but I am questioning if we're going to move forward with looking at this question around compensation, if we are answering with increasing efficiency in the delivery of public safety, also the equal distribution of public safety in the same way. Because one of the concerns that has been raised that I've heard is when you do have a profit motive for pulling people over for tickets, you are more likely to pull people over who you might not know. And in cases that I've seen, people who they don't necessarily recognize can also fall under certain characteristics that aren't, I'm trying to be very diplomatic about this. I don't necessarily know if my assumptions or the concerns that I've heard raised are accurate when we compare sheriffs to other public safety officials and the equal pullover rate of people of color or other marginalized groups. And this might be a very separate conversation from what we're trying to work on, but I would note that that feels very relevant to me when we think about the future of the question around profit, because I think that can unfortunately cloud some judgment.
So to respond, one, we could on line 2, on number 2, we could say increasing the efficiency and equity in delivery of services. In terms of the data about traffic stops and everything, I think, Tim, you might have more information about this, about what they're subject to in terms of data collection.
Yes, there's a specific statute, 20 VSA 2366, that pertains to law enforcement agencies, fair and impartial policing policies, and race data collection. And that's under the Vermont Criminal Justice Council statute, and it does apply to county levels.
It does. So
yes.
when they report their data, we can compare that to the public safety officials who are in the area.
I don't know the specifics of how the data is stored, managed, or published by the CJC. Question best for them, but I'm sure it's.
Well, it'd be great to have this task force look at that, and in relation to the profit question. Like if there's,
We could, I just want to make sure we're not putting too much on a 6-month task force.
if you throw in the word and equity, I will be.
But also the fair and impartial policing report should be able to call out which departments statewide are, what the data is on each one. Whether it's local law enforcement, whether it's Vermont state troopers, whether it's sheriffs, it should have that broken down.
So
Great. Tim, do you have something to add on this, on terms of
no, just I just
you
wanted-
have 5 minutes too before you have to go. Okay, let's mull this and we'll hear some testimony. We can add equity and efficiency, and then we'll mull whether we want to give them another duty. I think if you all could think about number 6 and whether that, and how we get to the sort of culture change kind of question, that would be great. We're gonna lose Tim because he has to go to our sister committee down the hall. So do we have any more questions for him at this point about the changes? Or there was one other tiny change that you don't see because it was just taking something out. that was requested by the Vermont Criminal Justice Council.
Yes.
That's in
Um,
section 1.
It was a proposed amendment that was returned to the original text, so no modifications to
Yeah.
existing statutes will be made there.
Yeah, there was just a phrase that I thought limited that, so we took it out in paragraph 2 on page 1, I believe.
Yes.
All right, there are no other questions for Tim. We reserve the right to claw you back and let you, and also to let you know if we're thinking about any other changes. So, but I'll be in touch.
Okay, that sounds great.
Okay, and I don't think we're gonna vote this out today, just so you know, we'll have more time. Okay, great. Thank you, Tim. So our witnesses are, the weather has challenged some of our witnesses, both the Sheriff's Association, Sheriff Anderson is without power and internet, so he can't zoom in. And Sheriff Marcoux is stuck on the road because of a fallen tree. So he can't zoom in either. So we're gonna obviously come back to them. That's one of the big reasons, but we're not gonna vote the bill out today. And I don't, are John and Andy, okay. But Terry, since you're here in person, would you like to go first and then we'll go to the Zoom people?
Oh, I don't mind waiting, and I consider myself very minor. I was just gonna report in terms of our interactions with the
That's
sheriff's department.
That's okay, you can go ahead, and then you don't have to sit in here unless you want to, we always love to have you. And, yeah, so why don't you just introduce yourself and tell us what you'd like us to know.
Thank you. Terry Person, State Court Administrator. And mainly I wanted to just report in terms of the Sheriff's Department, it was in the form of Sheriff Anderson, the Chief Superior Judge Zoni and I, over the week, did work out agreeable language for what was then sections 4 and 5, and they've been moved a little bit, but Legislative Council referred to the 2 sections where we agreed upon language in terms of a single contractual rate of pay. I believe that in the $51 per hour is based on the sheriff's suggestion and proposal. We were supporting that. I think they had in mind effective sooner than July 1, 2024 for the rate of pay.
Oh,
Yeah, why is,
for the contract,
that was the question I had, is why is it so far out?
I thought that there was,
There was a provision for July 1, 2024 for the requirement to provide at least 1 sheriff deputy per courthouse. Effective date of July 1, 2024, in anticipation, at least a couple of counties might need that time to ensure that they have at least one per courthouse. But the rate of pay, I think they anticipated
Being immediate.
effective with whatever the date for the bill.
well, so section 7 is the one that has the later start date, which is the provision of the 1 deputy.
Yes, on page 10.
Right, so that's the only thing that would start later.
Oh,
The other section would start,
On page 8, it does say 2024.
right. But it-
oh, I see.
So it might have maybe inadvertently gotten placed into the wrong section.
Okay, so if that were changed to July 1st, 2023, that would
Yeah.
work?
Yes,
Okay,
I think it-
okay.
that's my assumption. The sheriffs can address it, but I know when we discussed it, the July 1, 2024 date was only referenced in conjunction with providing the sheriff.
Got it. Okay, so this other section of the bill that's relevant, which is now on the top of page 10,
Yes,
paragraph E, that one will take place on July 1st, 2024.
yes, that's
This other one would, okay,
right.
great. We'll have Tim change that date if that was what you agreed on. And we are sending this, as I mentioned, to BGS to look at, and they can maybe give us some guidance on contract, clauses that the auto increase what the standard is.
And I think that makes perfect sense. They were looking for just something to reliable and a regular way versus every year coming in and changing.
Right. Great. All right, are there any questions for Terry?
I did have one question.
Sure.
And I, this isn't something that was discussed, but in terms of the oversight committee,
Mhm.
I didn't, or oversight task force,
Yep.
I didn't know if it would be helpful or possible to have a member of the judiciary included on the task force. I just thought in terms of if it's oversight regarding law enforcement, that might include courthouse security.
Yep.
So I didn't know if that might be possible. That's in section 11.
Okay. I will add that to the list of possibilities.
Oh, great.
And we'll see how many people we end up with, so it's not a giant task force.
Oh,
And then we could maybe swap out somebody, maybe instead of the AG's office, the judiciary. I did text the AG today to ask her to look at this section too, so we'll see what they say.
An assistant judge versus the judiciary, and
Well, the assistant judge is because they're the ones that sort of oversee county budgets and have to sign off on the disbursements of sheriffs after they said they leave in the office, and they often oversee the county courthouses, so
Yeah, they have more involvement.
it seems appropriate to have them. But we can ask.
you convinced me with those single sentences.
The auditor, it's unclear to me that the auditor needs to.
Yeah, the auditor
Yeah.
was mostly because there are all those statutes about audit requirements and the
Yeah, but
oversight of.
they then can audit at any point. I don't know why they would need to be on this.
We can ask them as we
And
have a few days, and if anybody's listening out there in the
who
atmosphere.
has power and is able
Who's
to.
listed here or thinks they should be listed here. Careful what you ask for, I suppose. Okay, anything else?
That was it.
Excellent. All right, thank you, Terry.
If it's okay, I probably will listen because
Sure.
otherwise I'd be back in my office listening.
No problem.
So
Hang
can I
out.
just ask Terry, at the moment, are all the courthouses staffed with sheriff's security, or have you, because at one point you were subcontracting it to other entities?
At this point in time, there's at least one sheriff's deputy in each courthouse except in Grand Isle. Otherwise, there aren't sufficient numbers of sheriffs per courthouse. There is it's a combination of Securitas, which is a private security firm, for example. Also state employees, primarily in the Shipman Costello Courthouse, which has been the tradition for some years. And then we've actually used pandemic limited service court, temporary court security officers because we just don't have enough to cover. That's a small percentage of the total, but it's a combination of those different categories of security in order to be able to open each courthouse at this point. I think 56% of the courthouse security is sheriff's deputies. And it's our preference for sheriff's deputies, but they've had the workforce shortage issues.
Thanks.
Thank you.
Thank you.
Senator Norris, can you reach that clock?
I was worried about that.
Can you change that clock?
I'm the door
It's kind of
post.
driving me nuts, and I was wondering if you're tall enough to reach it. Yes, I thought you might be. Oh, thank you.
Oh, look at that.
Last-
What? Okay, I guess I'll.
All right, we're changing a clock, but John and Annie, I see you're on the screen if you want to
2:34.
come on in.
Bam.
John,
Right?
um,
We could, if we could have Senator Norris come over and change our clocks as well. Yes.
super helpful. Thank you. Oh, it's a little crooked.
Wait, sorry, Madam Chair.
Exactly. Thank you, Terry. There
Say that
you
about
go.
Senator Norris.
No, I feel like the guy who puts in that show there, the star on top of the Christmas tree there.
Yeah. Thank you. That's very helpful. Okay, hi. I'm hoping you've seen the new version of the bill, which removed the reorg that we had put in there at your request, but then took it out at your request.
Madam Chair, well, first, John Campbell, Executive Director of the State's Attorneys and Sheriffs. I guess this highlights why you should be careful what you ask for.
Yes, exactly.
Yeah. But if I could just start out, again, we've tried to help out and try to be a assistant in this legislation and walk you through. and if you recall, and I unfortunately have to explain this to a lot of people, and this is also sort of the genesis of why I thought it was necessary to try to separate the two distinct entities, that being the sheriffs and that being the state's attorneys. As you know, and I know it probably doesn't, you all don't need to hear it again, but I think I just need to say it for the record, is that the Department of State's Attorneys and Sheriffs, the only aspect of the sheriffs that we deal with are the state transport deputies, and their salary of the sheriffs filters through us. That's it. We don't have any control over their day-to-day operations. We don't have control over their use of their deputies that are not the state deputies. And so with that said, I think it's very limited as to what sections here that we would be able really to testify or provide any guidance. I'm happy to answer questions, but if I could just give that initial caveat.
Yeah, that's fine. I appreciate that. And mostly we wanted you to come back because we had removed that section, and I just wanted clarification on the record that you are good with that. I mean, I have correspondence about it, but so that was one thing. And then if the whole section at the end about the report, you had suggested some reporting things. I think a lot of what you suggested is sort of embedded in here. And so if you had feedback on the little task force, the membership and the duties, that would be helpful.
Yes, Madam Chair. And what I had suggested was that we separate or study the separation, how to best do that, and to have the entities separated. This goes a little bit further, and it's a policy decision. There's, clearly there's not only interest, but I think there's a responsibility to look into how some of the offices, the sheriff's offices, have been operating, and again, a lot of the individuals that that have been highlighted in news stories, they are no longer here. But I think it would be in the best interest of all of the state and also the individual sheriffs themselves to have some guidelines. But those are guidelines that we don't have anything to do with. This task force, the only matter or issue that I would have is in your number 7, where it basically discusses the reorganization of our department of state's attorneys and sheriffs. And I know it says to better support the duties and operations of the state's attorneys and sheriffs, which sounds great, but when you get a large group of people and a task force, sometimes I think that they may take on issues that were not intended. And this is going to sound very self-serving here, but when Annie and I came on board in 2016, the department was one that was the state's attorneys were pretty much handling things themselves. They had an executive director, but it wasn't. They were. I guess they had different interests. But what we tried to do was to bring professionalism, to expand the training, to make sure that the offices were all manned with enough folks, to bring in new ideas and policies. And we've done I think we've done a very good job of that. And I think that, and I'll stand by that with the reputation that I think we have among the governmental community. And I just don't see the necessity for us or for this task force to look to or have them feel that their part of the responsibility is to reorganize our department. I don't think the Department of State's Attorneys and Sheriffs was part of the objective of this bill when it was first filed. And so I just feel a little uncomfortable with that section and would ask that number 7 be taken out. I think the rest of it all would encompass what the goals of the committee were, at least that I thought they were in the drafting of this bill.
Okay. So you no longer even want to consider the possibility of reorganizing the department? Is that what I'm
Well-
hearing? Or is it just that you don't want it to be part of this task force's duties?
I would probably say the latter, and I don't want to sound defensive, because that's really what it sort of comes across as, wait a second, don't look at us. That's not what I'm saying. It's just, I think that the two, I believe that if it's the goal to have the Department of State's attorneys and sheriffs to maintain the transportation program that involves sheriffs because of the fact that they're deputized under the different departments. We're happy to continue on with the service and that obligation that we do and carry it, I think, very well. It does concern me about being brought into further aspects of the business of the sheriff. And what I had said to you in my email, one of my concerns about the previous draft was that it sort of put an oversight we were sort of, this department was going to have more oversight on the individual sheriff's offices and their departments and operations, which I think that would just create further the conflict that I was trying to avoid. And maybe it's just something that, short of separating it out into two separate departments, distinct departments, that being the Department of State's Attorneys, and then a Department of Sheriffs, where you would have the executive director in each department, or whatever you want to call the person that would oversee and help set policies. I think we do it more, and I think Sheriff Marcoux has brought this up, is that this office, we function in a more conventional relationship with the state's attorneys than we do the sheriffs, because we have the responsibility for all of the state's attorneys' operation and policies and that matter. Whereas with the sheriffs, again, as I said, I don't want to keep it sounding like a broken record here, we just have the transport program.
Okay,
Oh.
we have a question here, Senator Vyhovsky.
It's kind of a question, kind of a statement, but previously you, when you had initially testified sort of supporting the separation of these two entities that there can appear to be, or perhaps is, a bit of a conflict of interests having them together. And that made sense to me. And the way I read 7 is that the reorganization of this department could be that they get separated into two departments, but that we want to sort of make sure whatever pathway we take forward is the one that makes the most sense. But I certainly, when you testified, it feels like about a year ago, but it was probably only a couple of weeks ago, that actually, and it's kind of what I'm hearing you say today, that actually having like the one department maybe doesn't make that much sense. And so for me, that's kind of why I do want to see this included, so that we can really look at, does it actually make sense to break these into two agencies, because it made sense to me when you set it forward a few weeks ago.
So that if the committee be willing to change the language and basically have the question be, have this task force look into the rational basis for separating the two entities, that I think that's fine. I just, what concerned me is that if the task force would then start looking into, okay, what should we do, or can we change some of the policy of, let's say, an individual office, and saying that, look into discretionary option, or I should say discretionary acts that the individual state's attorneys have now. So I just thought that it would potentially open this up to what could be a rabbit hole. So, but if it's the language, if you're comfortable, and I would be comfortable with having task force make a determination, and we would happy to present evidence of why we feel that there should be a separation between the state's attorneys and the sheriffs. That would be fine.
What about reorganizing the department or creating a new department? Or do you just want no reorg? I see Annie shaking her head no. So
But can I just say that?
hold on, Senator.
I'll let Andy. I'll go ahead, Andy.
Well, actually, I'm thinking that what we were originally I think what John had originally proposed and was trying to achieve was to have a situation so that there was more of a separation because of potential conflict as prosecutors and having to deal with some of the sheriff's issues. So I don't necessarily, when you were saying that language, Senator, I was thinking, I don't necessarily know that would do it either, but I think if everybody understands, trying to get to a point where we where people feel comfortable with the role of the state's attorneys and the role of the sheriffs as kind of being separate goals and objectives and whatever, that maybe that makes some sense. And I'm sorry, I didn't mean to shake my head. I was thinking as you were talking, and I'm not sure that achieved what you were trying to do, but I apologize for the head shake.
No worries. That's totally fine. We can mull this language a little bit more, and if you want to mull it too and suggest specific language, that's fine. Senator Clarkson.
So I think separating assumes an end. It's assuming that that's what the best solution is. For me, it's like reviewing this department and what, I mean, I think the word review and make decisions about what the best structure would be with these two quite different groups of groups of people, the sheriffs and the state attorneys. What is the appropriate structure? But it's reviewing it and seeing if it works and why it doesn't work and what the challenges are. For me, that's the opportunity, is we have the chance to review it, see what works, what doesn't work, and make a recommendation as to how we should go forward.
Okay, why don't we all think about the correct verbs? And we'll come back to this because I don't want to lose too much time on this wordsmithing as a group. The one other thing I just want to call your attention to, John and Annie, is that this task force would be staffed by your office.
Is that, should I say thank you?
Yes, that would be the appropriate response here.
Thank you, Madam
I just want
Chair.
to make sure that you saw that.
We did.
Okay.
We're happy to do that.
Okay, great.
Oh,
That's
wait,
the right answer.
Yes, thank you. The one thing I would point out that that I might suggest is that this does not have a limit on the number of, it doesn't even mean limit, but the number of meetings. Because so I think it might, especially that would help with the appropriation aspect of it, because they're probably going to want to know how many meetings you're planning on having.
Page 14, line 2.
Okay,
Not
then I'm.
more than 5 meetings.
Oh, sorry, my apologies.
That's okay.
It's allergy season.
No, totally fine. So that would, I mean, if the bill takes effect, it would July, August, September, October, November. It'd be 1 meeting a month, basically.
We're happy to do it. Happy
Okay, excellent. That's great. So if you want to think about that language and the right verb, and send something along to me and Tim to consider, that would be helpful, and the committee will do the same. Thank you both for your time today and for all of your assistance on this bill, which we will hopefully pass this week out of committee.
Thank you, Madam Chair. Thank you, committee. Senators, thank you. Bye-bye now.
Okay, so we are now moving to Jeanette White. Is she there? Okay.
Where is the 5? It's on page 14, line 2. So
Well, that's why it's all the way here.
Yeah.
There we go.
Senator White, the former Senator White, are you there?
Part of me is.
Hi,
Hi.
how are you?
I'm good. I'm good.
It's good to see you.
I'm sure this must be weird for you.
Yes, I wrote everything down.
Excellent. Well, thank you for joining us today. I think you know everybody.
Is there some kind of a lag?
No,
Not on our end. Is there a lag on your end?
Yes. Yes.
Oh, I wonder if it's because of the storm and lines that are down.
Well,
For joining us today. I think-
Do you want to go
Oh,
out and
do you
come back
have,
in?
do you have the YouTube on? You should turn off YouTube. Is there a lag on?
What am I supposed to turn off here?
Do you have YouTube running?
Are,
Because of the storm and-
is it there now? Am I there now?
You're here, but you are also listening to us on YouTube. That's why you're hearing the lag. So you need to turn off YouTube.
Oh. Turn off YouTube. What am I? Oh, wait, where now I went away completely.
No,
You're here.
You're-
We
you're-
see you.
We see you.
I can't see you. I can't see you.
Maybe it's behind a tab. You should see Zoom. You should be on Zoom and just the Zoom tab, not the YouTube tab.
Oh, for goodness sakes. I don't see a Zoom tab anywhere.
We can see you and hear you just fine. Can you hear us?
I can hear you. I wish I could see you.
Do you want to go out and come back in?
Yeah, you could do that if you want.
How do I do that?
You can leave Zoom, but if you can't see.
I don't see Zoom.
To leave Zoom. Close all your tabs. And then that might close the Zoom tab, even if you don't need to, and then you can get back into Zoom.
All right. Okay. Thanks, Olivia. I can still hear you guys.
Okay, yeah, we're just trying to help you.
I know, but I've gone out of everything I can. Okay.
Well,
She can hear us, we can see.
you can also testify, even though you can't see
Yeah,
it.
I-
We can see and hear you just fine.
Let me just do that because this is wasting
Okay.
too much
I
time.
can tell you who's in the room, so you know. We'll
Oh,
go around and
I've been
introduce-
watching you.
Oh, you know who's in the room, okay.
I do.
Okay, go ahead with your testimony.
All right, so good afternoon, Senator Hardy, committee members, and Olivia. I guess I'm in the right part of Wyndham County and not where Sheriff Anderson is, because we do have power, but we've lost it 3 or 4 times today. So if you lose me, that's why. And I will say this is a bit more terrifying than I had expected, so bear with me. And also, if I seem a little discombobulated, I just got this morning draft 3.3, and what I had prepared was based on draft 2.2.
Oh,
So I might jump around a little bit. So I was hoping to be able to come and visit someday, but sadly that hasn't worked out yet. I do want to thank all of you for your hard work on many issues and for being the committee to get the first bill of the biennium passed. Senator Doyle always insisted that GovOps got the first bill, and you have made him proud again. As you probably know, for some years, I have been working with law enforcement to make positive changes, working with senators, House members, law enforcement agencies, the AG office, Criminal Justice Council, and advocacy groups. There have been many positive steps to further support what I believe is essentially good law enforcement in Vermont. It, of course, can be improved, and for the most part, law enforcement itself is supportive and collaborative of those changes. A few words about our sheriffs, and I know you've heard all of this, but bear with me. By now, you have heard what a unique institution it is compared to sheriffs in other states, and the way most of us think of sheriffs, that they are there to protect us. I won't say any more except to reinforce that this is confusing to people, mainly because of the way we fund them and assign duties, and therefore impact their services. And just to say that the sheriffs are also unique in that they have more and different responsibilities than all other law enforcement officers. For an example of that is that they are personally responsible for the actions of their deputies. That's a pretty heavy load to bear, but that is what it says, that they are responsible. So to S17, I know you've heard from all the players, and I just want to add my perspective as someone with no real vested interest. I did have some comments on page 1, line 18, and I won't repeat them since you already deleted it. I was very happy to hear that you had deleted it. That's the one about the including any one or more of the following. So section 3, the auditor's language is primarily clarifying. My only comment here is around the cost. Sheriff's budget for planned audits, so they are prepared for them. They know they're going to happen. There might perhaps be a fund set up that would cover the cost of unexpected audits, since the sheriff's offices are funded in such an unsustainable manner that they really couldn't cover or budget for an unanticipated audit. I just the few minutes ago saw the new section for the conflict of interest section. It seems to me a bit complicated. Under the guidance of Senator Polina, as you know, the General Assembly passed a state code of ethics that includes a conflict of interest section. And I know that Tim talked about some of the differences with this and the state code of ethics conflict of interest, but why not instead just include sheriffs in the state code, therefore with in the conflict of interest? And you did have a conversation about whether municipalities and counties were covered. No, they are not. So assistant judges would be covered in their role as under judiciary. They would be covered under the judiciary code of ethics, but for their administrative roles, they would not be covered because they are not state employees. And the same would be true for deputies. So what would happen here, I believe, is that it could be very complicated for people like the transport deputies. So if there was any kind of even a small conflict between what you've proposed here and in the state code of ethics with the conflict of interest policy, if there was any kind of a conflict, where would the state transport deputies fall? Because they are state employees, so they're covered under the state code of ethics, but they are also sheriffs, so they would be covered under here. So I think you need to be very careful, and I would just say include them, sheriffs and their offices, under the state code of ethics. The contract for the courthouse, I think that's great. I'm glad you get that, and I hope it sticks. I'm going to skip section 5 for right now. On section 6, I make no comment now and about when the different agencies assist victims. But knowing how sheriff's offices are funded, I would suggest that the Crime Victim Services might reimburse for the service. As Senator White pointed out, you do not want a sheriff saying, I can't do it because I have no income for it. And yet they are only paid for things. They have to be paid for the services they're providing. So, and my understanding is that the Crime Victim Services used to pay for this and that they no longer do. And I agree, individuals should not be charged at all, but it does seem to me that there should be some compensation from someplace for this. And I believe it's the Crime Victim Services. I might be mistaken, but I don't see a section 9 in the bill. I see a section 8 and then a section 10. I'm not sure about that.
It's waiting for you to supply it.
Well, I would not open that can of worms, Senator Clarkson.
Be careful.
I would not do that.
Just joke.
Okay, so section 3, the task force, that is brand new, and I just heard John and Annie testify on that. And I'm not going to go through the duties or anything, except that I did have a question about number 6, and I know Senator Hardy, you brought that up also. That's the one that talks about not related to public safety service and then trying to get to their private contracts. But I'm not sure, but I think that most of the contracts, the private contracts that the sheriffs engage in, are aimed at public safety with the towns or with the ski areas or with even a highway construction. That's all aimed at public safety. So I think that they are related to public safety. So if you want to get it at how to get around the business model that they seem to be caught in, the only way to do that is to adequately fund them. So I will say that knowing that the misconduct of some of the sheriffs has been a concern, I was somewhat surprised that the written suggestions from the Sheriff's Association on how to deal with some of that misconduct wasn't more fully considered and wasn't included in any of the drafts. They presented, I think, 3 different suggestions of how to deal with sheriffs when they're under investigation, when they've actually been convicted. There was a whole section that they proposed, and I was surprised that there wasn't more discussion around that and consideration. Now I'm going to go to section 5, which I think is one of the sticking points here. I realize that the issue of 5% has caused a lot of angst and the optics around it are not good. My understanding is that this came about sometime in the 80s because it was easier than trying to raise the salaries. I know you have heard that there are about 170 positions in the Department of Public Safety that have higher salaries than the sheriffs. So I'm glad that this is going into the study, but I will say that given the responsibilities, particularly, for example, what I pointed out, that they are personally responsible for the actions of their deputies, that's pretty heavy. They should be adequately compensated. And I just looked up, a deputy state's attorney is paid more than many of our sheriffs, a deputy state's attorney. So I think their compensation really needs to be looked at. But under this section, I believe there are a couple distinct issues. One is that the sheriff can add it to his or her own salary. I would suggest that until the compensation study is done, this should remain the way it is in current statute. Perhaps just put a sunset on it, like at the end of June 2024. That should give time to address any recommendations that might come from the study. So that the 5% being able to add to the salary would go away in June of 2024 unless it's addressed otherwise. The other issue is even defining what an administrative fee is. So I write grants to HUD and other federal agencies for my place of employment. I also write grants to foundations. They almost always allow a certain amount, usually 15 to 20%, for an admin fee. Every department in the state government gets grants. Some specify an admin fee as part of the grant giver. In other, the state simply takes an admin fee, and often it is as high as 20%. So it makes no sense to limit this one agency to a 5% admin fee and then tell them how they can apply it. We don't do that with any other agency in the state at all. If we don't tell the Department of Human Services that if they get a grant, they have to limit it to 5% admin fee. So it doesn't make any sense to do it here. And admin fees are used for grant management, reimbursement for procurement, to pay grant writers, and to actually administer grants. So there are many uses for an admin fee. So the bottom line for me is that I would urge you to do nothing with this section. Leave the statute as it is, impose a sunset, and then if the salaries are addressed, delete the whole section and let the sheriff's departments handle admin fees the same way other departments and agencies do. Thank you for listening. I know your time this week is very precious and I appreciate it. Does anybody have any questions?
Thank you so much, Senator White. We have maybe time for 1 or 2 questions, but we have a couple other witnesses waiting and we're already behind. So Senator Vihoski.
Yeah, so the piece around the potential conflicting codes of ethics, I recall from our work on the code of ethics last year that it gave and carved out allowances for people with other codes of ethics. Because this was a concern of mine with my social work code of ethics. So I think that code of ethics actually already has language in it to say if you have another code of ethics that is stronger than this one, then that applies. So I don't know that that's going to be an issue. I just wanted to put that.
Well, we can ask our legislative counsel about that.
I would also suggest maybe talking to Christine Sievert about it, because it took a lot of work to carve out some of those. And the point was where there were very specific issues that only related, for example, to social workers. And the code of ethics had to be stronger than the state code of ethics. It couldn't be weaker. I just point out that you might want to check and make sure that there aren't any conflicts here at all, or it would be too confusing. Because in the departments, you have both state employees and non-state employees. That's all.
Yeah, I think your suggestion about potentially just adding them to the state code of ethics may be cleaner, but we will ask our legislative counsel about that. Senator White, or Clarkson, do you have something quick?
No, I thought, Jeanette, thank you. I think your suggestions are good ones for us to think about. I think particularly the code of ethics, incorporating that, and you're right, if we, it does make some sense if we're doing a whole task force looking at compensation to consider sunsetting this and doing it that way. So it's certainly worth thinking about, and I really appreciate your taking the time to do this. Have you sent your testimony in to Olivia?
Oh my goodness, Senator
Yes.
Clarkson, you know what my testimony always looks like because you
I know.
always ask
I
for my
love it.
reports.
Just take a photograph of it and text it.
No, I'll rewrite it and send it to Olivia.
Well, thank you so much, Senator White.
Really
And
good.
we appreciate hearing your thoughts on this, and thank you so much for your past service and work on all these issues. It's nice to see you. And
Thank you. I wish I could see you.
I know.
yeah, next time, come and visit us when it's not a huge snow day.
I'll
Yeah.
figure this out.
Thank you.
Thank you.
Thanks. Bye.
All right, we have two more people. Dave Silverman, is he on there? Okay.
He's marked now available.
No, they're
still.
They're not.
He said he lost power and I'm wanting to do something. So
Okay.
you can probably just.
Yeah. Hi, Dave.
Hello.
We are in the snow globe at the State House, and we currently have power. So we are behind schedule. So if you could just introduce yourself, maybe we can quickly introduce ourselves since you haven't been here yet. You know me, I'm Senator Ruth Hardy.
Olivia Parker, committee assistant.
Hey, Dave, Senator Tanya Vihoski.
Hi, Becca White, Windsor County District.
Bob Norris, Franklin County.
Ann Watson has stepped out, but hi, David, Allison Clarkson, Windsor County District.
Thank
Okay,
you,
great.
senators.
Go ahead.
Thank you, Madam Chair, senators, for this opportunity to speak with you. My name is Dave Silverman. I'm the High Bailiff of Addison County, and for a brief while last June, I was also the county's acting sheriff. I think it's safe to say that just about everyone in Addison County is relieved that our former sheriff is now finally our former sheriff. But the situation that we found ourselves in for 7 months last year should be viewed as a warning sign and something that all of our constituents statewide should never have to worry about again. Last June, Peter Newton was arrested for a series of sexual assaults. The survivor of those assaults is a woman who initially came to him as sheriff for help. She was exiting an abusive relationship and she was scared. She needed protection. Instead, what is alleged is that Newton trapped her in an even more abusive relationship, physically and emotionally, over the course of months. By operation of law, from the moment Newton was arrested until he was released following arraignment, I served as acting sheriff. But the moment he was released, and again by operation of law, Newton resumed his elected office. Nobody could do anything about that. The legislature was out of session, and impeachment was impossible. And while Newton was barred by a court order from engaging in law enforcement activities, he was still empowered to administer the office as the chief administrator of that office. That includes assignments, staffing. And even though, in fact, he never showed up, he kept drawing the paycheck, his name stayed on the side of the building, and the department continued to be sullied by association with him. Meanwhile, many residents of Addison County felt unsafe. I fielded a lot of calls and questions in those days. A neighbor of Newton's called me, telling me that they were afraid for their own safety. They were looking for a temporary place to live where they wouldn't have to face him. Select board members in towns that contracted with the sheriff's department for patrol services wondered how they could, in good faith, continue to receive services from a department led by someone so violent and immoral. Residents protested, but Peter wouldn't go. He wanted his salary, he wanted his pension. No one could make him go. We should be clear-eyed about what's going on here. Newton's alleged crimes may be particularly heinous, but his ability to stand above the law is not unique to Addison County. Another sheriff violently assaulted a civilian in his custody. Another sheriff embezzled nearly $500,000 of taxpayer money. Another plain up and left the state, kept drawing his salary. The list goes on. And it's tempted to chalk this all up to just a few bad apples. But when we allow ourselves to do that, we're just letting ourselves off the hook for the failures of the system for which we are responsible to uphold. A system with no accountability, no clear job description, just raw, virtually unchecked power. Plain and simple, if we're going to have sheriffs, and some might argue we don't really need them, at the very least, they need to be held to the same standards as every other law enforcement professional in this state. This is not the Wild West. We are a nation of laws. We must hold sheriffs accountable. I'll set aside my statements. I'll gladly answer any questions you have.
Thank you, Dave. Are there any questions for Mr. Silverman? Senator Clarkson.
So David, your insights as to how we address some of the challenges that the sheriff's departments have faced and sort of driven this entrepreneurial culture. Do you have any insights as a result of having been acting sheriff and having now being high bailiff and, looking at this sort of from 30,000 feet? Have you had any good insights for us?
Yeah, I think that's really a core part of the problem, that they don't have a specific remit. They are given tremendous power, but they can choose where and how and for what amount of money to wield that power. It is effectively a publicly financed for-profit private enterprise. And I think, when you give people a whole lot of power with no real set of responsibilities and very little accountability, you get abuse. And, we've set it up this way and it's what we've gotten.
Right, but we have, and I guess I'd follow up with, we have an opportunity to set it up hopefully slightly differently, to certainly examine it, come up with best practices. I mean, hell, there are 50 different states. We have best practices on sheriffs around the country. And we have an opportunity to do, a constitutional amendment. We have opportunities here. So what would you see as some of the steps forward? I mean, does this bill, do you think that the study committee is going to get at the compensation patchwork that needs to be fixed? It's driven a lot of this some of the challenges we face? What, do you see that this, I mean, what do you see as some of the solutions to any of that? Or do you think we're on the right track doing the task force and doing the things in the bill?
I think this is obviously a very complex system. And, I think the task force is helpful in that, the citizen legislature in a short session, is unable often to get to the root of the problem and come up with complex solutions to complex problems. So I think that's on the right track. And I think you're hitting the right point, Senator Clarkson, when you're looking to address the funding and the sort of private contract nature of it, because as I said, I think that's really at the crux of the problem. Yeah. And if we were to take a step back and reimagine this system, we would probably want to start with, what do we want from sheriffs? What responsibilities should they have? And if we start there and build it, if we were building fresh, that's where we would start. And if we started there, we would end up somewhere very, very different, right? We have this patchwork system where sheriffs plug holes that other agencies in the state are not currently addressing. Well, some of those holes maybe really need to be addressed by other agencies. Not clear to me why, for example, we have sheriffs ferrying people from DOC to court when the DOC gets nearly 10% of the general fund budget every year, $150 million a year. Seems to me they have a lot of money they could ferry people around. And they have significant expertise in how to handle people with care, I would hope. Some of the things we ask of them, maybe we can reallocate elsewhere, and maybe we end up with significantly smaller sheriff's departments. Maybe we end up with fewer sheriff's departments. Maybe we don't need one for every county. But you have to start with, I think, the fundamental question of, what is it do we want from these people? What do we want from this position? And then tell them, this is what we want. Rather than continuing to, try to add duct tape to this very, very broken system. It's not working, and it's not going to work until we kind of relay a foundation.
So just follow up with that. I don't think that we have actually then gotten it all back in what we're asking the task force to look at. I think, we don't ask, what do we need from the sheriff's department? What do we want from, we aren't asking those questions. We're asking.
We have a question about duties of sheriffs.
That's true. We do. So anyway, thanks, David. That's helpful. And I think we just have such an opportunity here.
Well, Dave,
thank you for addressing this problem.
If you it sounds like you've written your testimony. Have you sent that to Olivia so we can have it posted for the record?
I shall.
Thank you. That would be helpful. I think there's one more question for Senator Norris. Did you have a question?
Yes, just a quick one, Mr. Silverman. You advised that you took over the sheriff's office?
I'm sorry, sir?
You fulfilled the sheriff's duties when Newton was not there?
Yes, sir. I was acting sheriff for a period of roughly 7 or 8 hours while Newton was in custody. So the first thing I did was call into the office and spoke with the deputy in charge, who now is our newly elected sheriff, Michael Elmore. I asked Mike a series of questions, started with, what's the plan for the day? What are people doing? Mike told me that he had sent everyone home because he didn't want them interacting with the public and having to answer questions from the public about this, breaking news. I asked him what they were going to do before he had sent them home. He told me, well, we were just going to do road patrol today, nothing that can't be put off. I asked him what happens if there's an emergency. And he told me, to my surprise, he said, well, we don't respond to emergencies. That's the state police, or in the bigger towns, Bristol, Vergennes, Middlebury, the locals. And I asked, wow, so really there's an emergency anywhere in this county, you're not responding? He said, no, not unless one of the primary responders calls us for backup. So I asked him, do they ever call for backup? And he said, no, they really very rarely, if ever, do. Which to me really begged the question of, as we were just talking about, what is it that we have this department for? Because it seems like if they're there to do speed traps, then maybe we can assign that function to a different department as well.
Well, thank you for that oversight, but so the answer was 7 or 8 hours, sir?
Yep, that's the length of time that by law I was empowered as the acting sheriff of Addison County.
Thank you.
All right, thank you, Dave. Send in your testimony, and if you do have suggestions for the section about the task force, that would be helpful as well.
Thank you, Senator.
Yeah, thank you. Do we have our, oh, Chris Burkell, is he here? Oh my gosh, I totally skipped over him. No, I didn't. No, I didn't. Okay.
And then Garen Moore is.
Christopher Burkell, thank you for joining us. Hopefully you've gotten the newest draft of the bill, which does include the deletion of that little section, line that you suggested. But why don't you introduce yourself, and if you have other feedback on the bill, that's where we're at, of a specific feedback, if that's possible.
Sure thing. Thank you for the invite. For the record, Christopher Burkell, Vermont Criminal Justice Council, and the Deputy Director there. I did get a chance to grab this draft, but I've been in another committee, so I haven't had a chance to really digest it. I do see some definite differences from the last draft that I saw. So I'll touch on the parts that I had a chance to look at, and having not heard testimony from anybody else, I'm not really sure where the direction has gone with your committee.
Okay.
But, right off the bat, under section 1, I do see the removal of the former language, and it now reads just "and shall include," which is much appreciated. I think that does not hamper the work of the council and the professional regulation subcommittee in what they're looking at for professional misconduct. And sections H and I, the additions to the category B offenses, as I think I've mentioned before, relative to a sheriff's reform, I think that we have the ability to address those behaviors without specific language, but the specific language doesn't hurt. It's just additional parameters by which we could articulate if something didn't happen to fall into a very neat package for a specific category violation. Then that might just be additional work for the subcommittee to actually work with. But I do believe that that reference back to "shall include" pretty much allows the subcommittee to look at almost all policies that agencies have, and then look at gross professional misconduct and hold people accountable for that. I did notice towards the very end that there was a task force put together to do a number of things in this study. I don't have any disagreement with that. And in fact, I think it's probably a good idea, because there are quite a few sheriff's agencies I have worked with over the years who do excellent work. But it's no mistake that you see some issues with sheriff's departments that don't follow what the norm is. And so really getting a handle on what does the state of Vermont want for responsibilities for sheriffs. And as you're well aware, we have, at least right now in the governor's recommended budget, we're looking at a total curriculum overhaul. And that starts right out with a job task analysis that we send out to all Vermont agencies. And that gives us an idea as well as to just what do the functions of law enforcement do? What different sectors do what? Where is there overlap? And where is there things that may not need to be done by certain agencies or specific to sheriffs? So I think that a task force is probably a good idea with all of those partners. You'll get a very varied array of those responsibilities, and probably drill down to some things that might be either added responsibilities that are already done within another agency, or you might find other areas where sheriffs could be beneficial that current law enforcement agencies don't either have the depth of the bench for personnel to take care of, or specific responsibilities that the sheriffs have specific training for. I would like to go to one section that perhaps you can clarify for me under section 2. And I'm looking at the responsibility of what I assume is for transport deputies. Would that be correct? Isn't that what that section is attempting to address?
Section 2, the audits?
Nope, section 2 under County Sheriff's Department, where it says full-time
Oh,
state.
you know what?
deputy
This, section 2, the first paragraph B, is that what you're asking about?
Correct.
Okay, so that might actually come out of the bill. Now that you've called it out, I have to ask our drafting attorney, because this was part of a reorganization of the Department of State's Attorneys and Sheriffs, which we have backed off on because the department no longer wants us to do that. So this, I'll ask if this would need to stay or not.
Oh, good question, yes.
So this is mostly existing law. And this crossed out section on page 3 was actually going to be moved as part of a reorganization. It wasn't going to be eliminated, it was just going to be moved.
Okay.
So
what I assume then the bill is going to continue where it is on page 3, and that will remain the same with the executive director's responsibility?
Yes, the line 1, the executive director shall have the authority, that
Yes.
starting there, that would stay as current law, yes.
Okay, so here's where I see a potential conflict with the way that currently reads. Unless I've tried to get clarification answers to this, and I haven't been able to find that, so perhaps members of your committee or you can enlighten me on that. In the way that the current law is written, it gives the executive director of the Department of State's Attorneys and Sheriffs basically the final approval of personnel matters, including discipline and termination. And so if that be the case, for instance, if you had misconduct on the part of a state transport deputy who falls under the direction of that executive director, what set of policies does the executive director have that hold that law enforcement officer responsible? Or does that state transport deputy fall under the policies of the elected sheriff?
I think that is a good question that we can ask our, we haven't actually looked at that specific language because it's just kind of in here by coincidence. But it's a really good question and we can ask our legal counsel. My understanding is that the state deputies are basically supervised by the department, but we can get clarification on that. And what, do you have a suggestion for what, if that is the case, what might need to be changed?
Well, perhaps, and I'm not looking to try to mess up with sections that you've already dealt with and moved on, because as I said, I didn't hear earlier testimony, but my assumption is that any deputy, whether it be a transport deputy or a deputy sheriff, is first sworn in by the sheriff, who now is employed by the sheriff, but may be overseen by the executive director. And if I'm incorrect in that, I'm happy to be corrected. But where I see the problem is that if there is misconduct on behalf of that employee, who is the person responsible to make the report of misconduct to the council? Is it the sheriff, the elected sheriff in that county where that deputy works? Or is it the executive director of the Department of State's Attorneys and Sheriffs who now has the responsibility of the discipline and termination? Because, and the reason that I ask that is because if it's the sheriff, the sheriff has a legal responsibility through professional regulation to make a report to the council of that misconduct and then conduct an internal affairs investigation. If it's not the sheriff's employee and it's the executive director likely doesn't have policies, nor is there a requirement for the executive director of the Department of State's Attorneys and Sheriffs to make a report to the council. And if the executive director did not, the council couldn't even take any action because there's no requirement for a report to be.
We can ask our counsel, it might be also helpful if you could reach out to Director John Campbell at the department and ask him this question.
Be happy to do that.
He may even be watching this conversation right now, because my understanding is he does supervise them. They are state employees. So if there were misconduct, he would be the one doing the report and investigation. But if there's something that we might need to change to make sure that that happens and complies with your requirements, then we could certainly do that in this bill. That would be relevant. So if you're able to look into it from your side and we can from our side, in the interest of time, we'll probably be taking this bill up again, and then we will be in the next couple days.
Absolutely. Yes.
Okay.
I don't want to get you bogged down into a side discussion.
Okay, that's great. Thank you.
Yes, as to the rest of the amended bill, I haven't really had a chance to review the rest of, other than the task force part. As to I did notice the section about the 5% administrative fee, and it looks like there's, pretty specific language as to how that fee can be used. What I've heard in the past as a concern from sheriff's agencies is that while they are different than any other agency who would have legal representation if there was a violation of policy and then there's litigation, municipal agencies, constables even, and state clearly have their own legal counsel to do that. I don't see anything in the way that this new bill has been crafted that would prevent sheriff's agencies from using part of that 5% administrative fee. It says for professional services, so I would assume that could mean legal services as well.
Mm-hmm. Yes.
So I think that that's been addressed in there, and short of that, I probably wouldn't be the person to speak to anything about the 5% administrative fee that's currently in existence.
Okay. Just related to the task force, the Criminal Justice Council would have a member on it, and you're okay with that, I would assume?
Absolutely, yes.
Okay, great. We have one question and then we're going to have to move on. Senator Biegovski.
Yeah, it's sort of the question around the state employee piece. And I just want to clarify, the Vermont State Police are also state employees, correct? And you have the ability to oversee and engage with them, right?
That's correct. They have their own state policies. They have their own internal affairs investigation division.
Okay. I just wanted to clarify, because it sounds like there's some sort of conflict with the state employees and the Criminal Justice Council, but that isn't an issue with the SP.
No.
Okay.
Yeah.
Can I just ask?
Yeah, quickly.
Chris, thank you for your input. I just would ask, are we asking the right questions with this task force? And do we have the right membership on the task force? Because I think you have insight into that, and I would appreciate your input on that.
I do think you have all the right players in there. I do think that I just don't see where there might be some other group that is outside of law enforcement or the legal realm that might have or want to have input into sheriff's responsibilities, such as like Department of Mental Health. I mean, they clearly have a large working relationship with sheriffs. Would that be an agency that might have insight into the work that they do with them?
Yeah, and the judiciary has to be included.
Clearly, yes.
All right. Well, thank you, Christopher. And as you look at the rest of the bill, if you have further thoughts, we can certainly have you back when we take this up one last time.
Be happy to do that.
Really appreciate it. Have a good afternoon.
Thank you as well.
Is Carrie Moore still there or not? Okay, so our last witness is no longer on Zoom with us. So we are going to actually skip our break and move to the next bill, because I'm afraid we're gonna lose Becky. Are you able to do this now or not?
I can, yeah.
Okay.
Do you need, if you need a break, I can.
If people need a break, can you take a personal break? I also have cheese and crackers if people want something that's not. Oh, and we have more cookies from Terry.
Oh my gosh,
If you
We have so
I
much
have
cookies.
cookies, we have cookies.
Oh,
I can say.
Thank you.
But those are not.
We'll start
So
down
this
here.
is why you turned down our cookies. You knew where the real deal was. Okay.
Does anyone want cheese? All right, I will save the cheese. All right, we are gonna, we are still live on YouTube, remember, everyone. Take a break if you need it, but we are gonna move on, I think it's.
Let's move on.
Pass
Only
on
one of
your
us
cookies
down here, Nora. Here are copies of the bill.
Where's Sharon?
Hey, Clark's
Oh, wow,
here,
wow,
Laura's
there.
here, he's and luck for the day.
Is she on today?
No.
No, you can't. Thank you for your, and we'll follow up with it.
Okay. They have-
Have the cat.
Hi, guys. Thank you for your patience as we're behind schedule. Would you like a cookie?
Oh, cookie we
We
want.
have cookies.
We have cookies.
Terry very kindly.
No, thank
Doesn't bode well.
Yeah, they're Terry's. Hi.
Hi, I'm Laura, I'm with WCX. Is it okay if I just get behind you over there?
If you could be over here, that would
I'd
be
be happy
helpful.
to.
Yeah. All right. Is Mike joining us on Zoom?
Yes.
Okay,
He
great.
said he's in the waiting room.
Okay, yeah, you can let him in. Yes, it's right here.
Oh, did it just
Yeah,
get passed around?
I put it right there and you just gave it to
Oh,
me
sorry,
back to me. Yeah, you can let him in. Oh, you can let David in as well. Oh, I just sent a whole pile of them down there. Did it not make it?
Thank you.
Okay. So we are moving from sheriffs to divestment and S42. As you'll recall, our last day before the break, we had some testimony. We asked, you have one right there.
No, Thomas.
You have an extra.
Oh, do we have, I sent a pile of them that way.
I
One
have
have
8
two.
in that pile.
Okay, Senator Norris has them. There, can you give one?
Senator Norris.
I think we didn't have a copy.
We have 8 copies, so that
Thank
is,
you.
Anyone not get a copy? Thank you.
okay, that's all we have, so
And her copy.
that should be for Ann. Okay, so our last day here, we took some testimony, and it was clear that we didn't have total agreement, and we really wanted to see if we could move forward with some kind of bill on divestment. So we asked VPIC and the treasurer's office and some advocates with Third Act to talk during the break, which they did several times. Thank you very much. And come up with agreed upon language, which hopefully is reflected or mostly reflected in this draft that Becky's going to walk us through. It's different than, so if you want to take us through the whole thing, since
Sure.
it's all new, that would be great.
Becky Wasserman, Legislative Counsel. This is draft 1.3 to S42, and it is a strike all amendment. So the underlying bill is struck out. I think the previous version you saw had instances of amendment, if I recall correctly. So this is making a number of changes, which is why it was presented as a strike all instead of instances of amendment. So I'll walk through all of the changes. I will say that just to clarify for everyone that worked on the proposed changes, that I couldn't incorporate some of the changes that were presented in the draft I received because they were changes to the statement of the purpose of the bill, which we are not able to change in an amendment. It only is in the bill as introduced. So to the extent any of those changes are not reflected in the body of the bill, if there's another way that I can reflect that, I can talk with everybody about how to do that.
I totally don't understand.
So when you introduce a bill, there's the statement of the purpose of the bill. So that doesn't follow the bill if it is amended. It's just in the bill as introduced.
Right.
So when you see an amendment, that statement of purpose isn't included.
And that statement of purpose doesn't include the intent and all the findings and all that stuff. It's just the statement of purpose.
It's just the statement of purpose of the bill as introduced. Yes.
So some of the stuff, maybe we could put in an intent or finding section of the bill.
Exactly, yeah. So I just wanted to open that up as if some of those changes aren't reflected in here, I can reflect them in some other way, like for example, findings or intent in the bill. So section 1 of the bill is establishing the plan and report for the divestment of public pension funds. Subsection A, so I'm on page 1, line 10. The definition section here was amended to remove a number of the definitions. The bill as introduced had definitions for fossil fuels, fossil fuel company, and this is changing the definitions to just carbon footprint and de minimis exposure. So the first definition for carbon footprint means the extent to which holdings are invested in stock, securities, or other obligations of any fossil fuel company or any subsidiary, affiliate, or parent of any fossil fuel company. And then the definition of de minimis exposure, this is different from the definition that was in the previous draft. This means the aggregate amount of all fossil fuel holdings in the portfolio amounting to less than 2% of the aggregate amounts of all funds invested. There are some additional language in the subsection D of this section that asks VPIC to further define fossil fuel and a methodology for coming up with the de minimis exposure. So I'll get to that later on in the walkthrough. Subsection B is the review that VPIC will be conducting. So on or before December 31st, 2023. So this date was pushed from November 1st to December 31st of this year. In consultation with the State Treasurer's Office, they will complete a review of the carbon footprint of the holdings of the 3 retirement systems, the state employee system, the teacher system, and the municipal employees retirement systems. And then subsection C on line 3 is a plan that they will have to come up with. So subdivision 1 says that except as provided in subdivision 2, the commission, in accordance with sound investment criteria and consistent with fiduciary obligations, shall develop a plan to divest. So first is any holdings that are identified in the review on or before December 31st, 2030, and then any asset classes identified in the review on or before December 31st, 2040. So there's a timing difference between the investment of 2 types of investments.
Okay.
And then there are 2 exemptions from this plan. So first, in 2A, nothing in the plan precludes de minimis exposure of any funds held by the commission. The stock, securities, or other obligations of any fossil fuel company or any subsidiary, affiliate, or parent of any fossil fuel company, provided, however, that the plan shall contain a clear long-term goal of divestment from these funds. And then B is private investments that contain fossil fuel company stock, securities of any fossil fuel. Sorry, I think there's a repeat there. The fossil fuel company stocks securities of any fossil fuel company or any subsidiary, affiliate, or parent of any fossil fuel company. An obligation shall be exempt from the plan until the commission determines that divestment is prudent and consistent with sound fiduciary practice. So I think there's an extra fossil fuel company in there.
It should just go to straight to subsidiary.
Yes, fossil fuel company stocks, securities, or any subsidiary affiliate, yes. And then subdivision 3, as part of this plan, the commission also has to include, as I mentioned, a definition for fossil fuel company, as well as a method for determining the metric of the portfolio's carbon footprint that allows for an exemption of private investments for the purpose of determining the de minimis exposure.
Okay.
So section D is a reporting requirement. So the date for this initial report was also moved in this version of the draft. So the first report is now due June 1st, 2024. The commission is being asked to report on the review and plan to the House and Senate GovOps committees and to the Joint Pension Oversight Committee. Subdivision 2 has beginning January 15th, 2025, and then every year after that until January 15th, 2030. Another report due to those same committees on the progress of divestment. The report would specifically have to include certain information. And this first in subdivision A is something that was not in the comments provided, but was something that came up in the committee the last time I was here. So I just wanted to confirm whether you wanted to keep this with, but the committee had discussed including an update on the composition and percentage of exposure of any investments that were exempt from the divestment plan. So I kept that language in for committee discussion. And then also a summary of the fee impacts in any instance of excessive charges or demands related to the rebalancing of the funds consistent with the implementation of this act. And then a final report is due January 15th, 2041 regarding completion of divestment.
Okay.
So section 2 of the bill is there are 2 appropriations. First, in 2024, $100,000 in general funds to VPIC to conduct the review and develop the plan. And then subdivision 2, and I need some confirmation about which retirement fund this should be coming from, but $254,000 appropriated to VPIC for the establishment of 2 staff positions to support improvements and efficiencies in the administration of the commission and to meet the review, planning, and reporting requirements of the act. So right now this is coming from I put the Vermont State Retirement Fund. I don't know if there's a specific fund for VPIC that this should be.
We've divided by a certain percentage based on the fund size. So it's a portion goes to VEMRs, a portion goes to VESTers, a portion goes to VESTers. I think it's like 40, 40, 20, something like that.
Is there a specific fund it comes from?
Those are 3 separate funds.
Okay, so which?
Per formula.
It's through a formula, yeah. Yes.
The pays for common things.
All of our budget comes from that allocation breakdown.
JFO has those breakdowns.
Okay, so it would come from each of the separate systems.
Proportionally.
This version of the bill removed the changes to statute that would go into effect in, I believe it was 2028. That would sort of put a prohibition in statute for investing in certain fossil fuel investments. And I think the intent is that as part of the progress report, recommendations on amending the statute would happen sort of as it gets closer to that date.
Okay. So this is totally new, and this is the first time we're through it. So are there questions for Becky at this point? Senator White.
So I just want to understand, this feels like we are taking a step away from divestment in a way that I had not necessarily anticipated the bill going. And I'm wondering if I'm understanding correctly what the real world implications are of the changes.
That may be more of a question for our witnesses than for Becky, I think.
Okay.
Yeah,
Yeah.
do you have a statement?
Yeah.
I think I would say that this is, one of the big changes is to the definition of de minimis exposure. And so the exemptions, my understanding in this version, are less than they were in the previous version. So there are fewer exceptions and fewer things caught by that de minimis exposure definition.
Because this is more of an aggregate of all funds rather than an exemption of some funds.
Right, because I think the previous version had like whole fund classes versus this is just exempting private investments, but the review is looking at specific asset classes, which the previous version did not do.
So now I'm re-confused, which is, in plain language, does this bill, it does not divest us from fossil fuels.
Wait, Senator Clarkson. Why don't we hold that question for the witnesses? Because one specific question, maybe this gets to a little of what you're asking, is I don't actually see in the bill, there's the plan and the review. There's not an actual language that says you shall divest.
Yes, exactly. Is that taken out and I'm missing it?
It seems implied, but it doesn't seem as direct.
Yeah, so the previous version had a date in which statute was changed to sort of have that statutory, you shall not do this any longer. And I think I don't want to speak for the intention as to why that was taken out. I think because it's a date far in the future and the committees will be getting annual reports on this topic, it is something that the legislature could speak to based on that report as you get closer. You could also include the prohibition now in statute.
Okay, are you able to stay with us? Okay, that would be great. So hold your question, we can ask.
I just don't want to be mad if I'm not unnecessarily reading the language.
Hold your fire.
Okay, thank you.
So we are gonna we first have Treasurer Pichek, and in fact, you can stay right there if
Oh,
we have Zoom witnesses for now. So Mike, thanks for being with us, and thanks again for getting the group together to talk about this. So why don't you tell us, you heard Senator White's question and my question, and if you could speak to sort of what process you use and then how you arrived at this language and why, that would be helpful.
Yeah, no, absolutely. Thank you, Chair Hardy, and thanks to the committee for having all of us in today. So as you pointed out, we did convene, the leadership of VPIC and the leadership of Third Act that has been really interested in moving forward on divestment, and had really productive conversations among those groups. And really, I would view us as just facilitating. They took the lead in terms of discussing what their top priorities were, what they wanted to focus on, where there were areas that they could not cross because it would put either the goals of divestment or the goals of being able to invest the pension fund successfully at risk. So this was an agreement, an amendment that was added to, I would say, from the amendment we previously talked about. The folks from Third Act took the pen on this, so it was sort of them coming together from their perspective after hearing from VPIC and the concerns that they had around, where the line should be drawn. And it is a, from my perspective, I also just want to thank Becky too for being able to put this draft amendment together so quickly, I should mention. But, I think the new amendment, it addresses the fact that this is an important issue, and also it's a complicated issue, and that it's something that should be done with deliberate action. It's something that should be done in partnership with VPIC and the legislature, and I do believe that the amendment would sort of create a framework for that, so that VPIC is reporting, it's held accountable, but it is also in the driver's seat in terms of coming up with a plan for the direct holdings, for the index funds, and then ultimately for the private funds as well. But it accounts for that very unique situation for Vermont, where we don't have always the full force of other states in terms of how we're able to get different asset managers to move in certain ways because of our, even though it's a big fund for Vermont, the limitation of the size of the fund relative to the rest of the investing world. It definitely recognizes the efforts that VPIC has made to date to transition the portfolio to a lower carbon footprint. So I think that is good as well. I know maybe some of that will get moved to the findings, but I know VPIC was very appreciative of that because they have done quite a bit of effort on this front, and they have put in quite a bit of time. It also does, from my perspective, no harm to the pension fund in terms of being able to make appropriate investments in the short, medium, and long term while being consistent with the transition to a lower carbon footprint and portfolio. And I think also importantly, it does not impinge on VPIC's fiduciary duty obligations. So, those are really important considerations, as well as giving VPIC the flexibility to continue to do engagement as they transition and continue to transition the portfolio. So I think all of those factors were balanced well together into this amendment. Gavin Boyles, our deputy treasurer, is there also to answer specific questions, but it's something that really came out of sort of thorough and detailed conversation, trying to balance these complicated factors, but recognizing the importance of the overall mission to move toward a decarbonized portfolio and continue the work that VPIC has been doing.
Great. Senator White, do you want to ask your question directly?
Yes, so this bill does not divest us from fossil fuels. Is that correct?
I think the, if you think of the previous amendment that we talked about, there was a de minimis exemption that is now more limited. The 2% is now applying to a much broader array of investments. So that's narrower. So would the previous amendment have completely divested? No. Would this amendment completely divest in the short term? No. But if you completely divest in the short term, you're sort of balancing that against the possibility and quite frankly, the likelihood of investment returns being harmed. Not because, again, the fossil fuel investments are so important and so spectacular, but because they come in vehicles that have a whole host of other investments that are important and critical to make. And then also you run the risk of the challenges around expense as well. So, they do contemplate plans for both the index funds and then ultimately, eventually, the private equity and private credit funds. But doing that on a timeline that is manageable and more, I think, more balances that against that likelihood that you're going to have harm to the pension funds in the short term. And then it does retain the fiduciary duty of VPIC, which was something, and I believe in the previous amendment as well. So ultimately, that is something that will be left to the discretion of the investment professionals with VPIC in terms of how to execute on that plan.
Okay, Senator White?
So I really do want to understand this because I do not want to be disappointed in a bill that is making progress forward. So I just want to be very clear. What I'm hearing is that this is an improvement on the previous bill. Because
think that's
more
true.
funds are going to be, there will be less money going towards fossil fuel. Is that an accurate, like, I don't know why, maybe that's a complicated question that I'm not understanding, but I just would like to know that so I can feel confident in supporting or not supporting this bill. Does this amendment reduce our fossil fuel investments sooner with more money than the previous amendment?
It certainly applies, Senator White, to more of the investments with VPIC.
Okay.
There's less exemptions for funds. I think I would suggest that maybe David talk a little bit about it from his perspective and how it does reach their concerns around moving the divestment on a path forward and on a certain timeline. He just very well may be in a better position to sort of talk about it from that perspective. But you know, the challenge here, as it's been a challenge from the beginning, is how do you know, if you're trying to achieve complete absolute divestment, regardless of the timeline, there are challenges with the Vermont portfolio in terms of not being able to utilize index funds, and also how do you navigate the ability to invest in private equity and private credit in the future, given our potentially limited bargaining power. So with those considerations, I think this bill moves forward in a much more concrete way.
Okay.
But I think David would speak well to that.
Yeah, so thank you, Treasurer. Are you able to stick with us for a little bit? Okay.
Yeah, for sure.
So I know there are other questions in the room, but I think maybe going to David McColgan right now would be helpful. And
Can we get rid of that little
Becky,
square?
Can you hit the X up there and get rid of that square on the screen? So
I think you just have to touch it.
Yeah, there we go.
Thank you.
Can I just speak to the
Yeah.
timeline issue?
Yeah, so if you have some clarifying, that would be helpful.
So in terms of the previous version of the bill, the Duress Holdings, the same timeline as the previous version of December 31st, 2030. The last version exempted from the plan investments in index funds, private equity, and private credit funds. This bill is not exempting all of those things, only private investments. So it will look at asset classes from those funds. I don't know if I'm using the right words, but that timeline, so it's including those now, but the timeline is longer. So it's December 31st, 2040, that the plan is saying that the state will have to digest from
2041.
Yes, that's
2040, and then the report is due in 2041.
okay. Thank you for saying that. That's all I would like to know. I don't want to be against this bill, but I am confused about what it is doing. And now I feel, thank you, Becky, that you've explained it to me and what it is doing. And now I do disagree with the timeline change. That I disagree with.
Okay.
Now I understand where the point of concern is.
Okay. And we can revisit all of the bill. That's our job as the senators. So, but let's hear from more of our witnesses. And Michael, we are still going to be a couple more minutes on this.
Do you want me to come back in 15 or whatever you like, Senator?
15 would be great. You're
So
welcome to stay with us, but I don't want to waste your time. So how about?
When I come back at 4:20?
Sure, that sounds great. Thanks, Michael.
Sure thing.
And Tom, you can sit back down there. I just, you know, that's chair's reserved for attorneys, so I didn't want him to be standing. Okay. So David, thank you. You've heard some of the questions from Senator White and others, and you were the sort of advocate from Third Act that was involved in these. So if you could speak to those questions and what your thoughts are on this bill, and that would be really helpful.
Sure. Thank you. Again, my name's David McColgan. I'm a retired attorney and member of Third Act Vermont. And I really appreciate your giving us the opportunity to testify regarding this and also to be involved in discussing the language with VPIC and with the Treasurer's Office. We worked very closely in this process with a financial and pensions expert, Tom Sanzillo from IEFA, which is the Institute for Energy Economics and Financial Analysis. And he's somebody who himself has worked very closely on divestments with Bill McKibben, who very much started the divestment movement in this particular area about 15 years ago. And the language that we have before us was actually drafted by Tom Sanzillo as something that would both meet the concerns of VPIC and the Treasurer's Office regarding their fiduciary duties, meet their concerns regarding the difficulties of divesting from private equity, and at the same time provide real divestment, particularly in the index funds, and also a path forward for potentially divesting from private investments if VPIC determines that that can be done in a manner that's prudential. So this is language that we do support. Our expert crafted it and crafted it as language that would result in real divestment. And we're quite confident in his advice and his analysis of it. I do see, I've just reviewed the language, and I do see some things. I'm glad Mike is still on the line there. I do see some things that I think need to be clarified that I think may also clarify the issue for the committee. We have these two dates. If we look at page 2, lines 7 through 8 call for the divestment of any such holdings identified in the review by December 31st of 2030. So that's the first date. That's intended to apply to everything except for private investments. So that covers index funds. Now that's significant because the largest category of the holdings that VPIC has right now are in index funds. So that's a huge chunk that does need to be moved into, over a period of years, into funds that are free of fossil fuels. The second, and this is where the clarification is needed, is in the second provision there, the second date, which is on lines 9 and 10 of page 2, where it says any asset classes identified in the review described in subsection B of this section on or before December 31st, 2040. Now, reading that, you're going to wonder, well, what's that referring to and how's that different than subsection A? And why do we have a separate date for it? We've got two different dates going on. I think that this needs to be clarified to make clear that what we're talking about here in subsection B is the private investments. And that encompasses, in particular, the private equity. When we spoke to VPIC, they were very concerned about anything that would require them to move quickly out of private equity, because a lot of those investments are on a longer timeline, 5 years, 10 years, 15 years. And to pull out quickly could cost a lot. There's a substantial penalty for doing that. And so what we have done is structure this so that to the extent VPIC ultimately decides that they can prudentially divest from private equity, that would be done by 2040. So that's why we have that second date. Now, the language I would propose to insert there in place of what is on lines 9 and 10 to make clear that we're talking about the private investments here. And I can email this to Olivia Parker, but I can also read it right now. And I did email it to Mike Pichek and also Tom and Eric. I'm not sure.
David, why don't you read it right now so that we hear it? Because we're the most important people to hear it right now.
So this would be to lines 9 and 10 of page 2, parens capital B, any private investments exempted under subsection C2B of this section, identified in the review process described in subsection B of this section, on or before December 31st, 2040, if the commission deems divestment to be prudent and consistent with sound fiduciary practice. Now, if we put that in, what that does is it clarifies that we're talking about in that subsection B, we're talking about the private investments that we also talk about down below under exemptions. If you look at 2B, line 17, where it's creating an exemption for private investments. And it says that exemption shall exist until such time as the commission deems divestment to be prudent and consistent with sound fiduciary practice. So this would link those two up and make clear that that second date of 2040 is for those private investments once VPIC is able to determine that divestment from those private investments is within its fiduciary obligations.
Okay. If you could send that language to me and Olivia as well, that would be helpful. And Becky, I don't know if you, we can send it to Becky, but and we can hear your reactions to that when you all testify. David, I have one question. That's the question there's nothing in this bill right now that says that the state shall divest or that VPIC shall divest funds. There's just a plan for divestment. It's sort of passive. And can you speak to why there's not a shall statement in here anywhere?
I agree. And I appreciate you picking up on that because I think, frankly, we just missed that. It's like, well, if we plan for it, then we'll be done. But I think it's an excellent point, and I think we can correct it very easily on line 6 of page 2, where we've got the phrase shall develop a plan to divest. If we just insert the words and implement. So it would be shall develop and implement a plan to divest.
Well, that would change it significantly, I think, because this is under the section that says plan. So I guess I would ask Becky if that doesn't seem to make sense to put it there. But we can, okay, I think we can toy around with where to put it in the bill and how to put it in the bill. But thank you for confirming that. I was like, wait, what is it? Where is it? And that's
exactly what I've been trying.
Yeah, exactly. Okay,
thank you.
And yes, we will hear from you guys. I know you're sweating in the corner over there.
It's just
Senator Biehoski had a question.
So when MCSL came and testified to us, they talked about more than simply divestment, but they talked about environmental, social governance, ratings, and scoring. And you know, I think that one of the concerns I have with the narrowness of only looking at carbon impact and only looking at divesting from fossil fuels is we're not getting at that bigger picture of environmental and social impact, and could potentially allow for investments in sort of greenwashing and sort of looking better on paper, but not actually doing less harm. And so I'd really love for us to explore the possibility, whether that was in the report or the plan, and actually using that environmental social governance as how we're gauging and measuring divestment and what we're doing. And I also think that potentially gives us the opportunity to be looking at more than just fossil fuels. I mean, I don't know, is the pension fund still invested in blood diamonds? I don't know. But like, I really want to look at that broader picture.
Senator Watson, okay, Senator Clarkson.
So I think one of the things we're missing here is the intent findings, because I think that also can be reinforced in what our objective is with this bill, which we're not missing altogether. So to go to your concern, for me, those are very important. And because they state what the objective is, and you don't get lost in all the dates and what we're trying to do. But I think it's terrific that I really applaud your work together. Thank you very much. I think that we need a plan, a framework, and a date certain. So I think that's what we're all looking for. And I think in some of the reports, Tanya, I think that those are great, would be great additions. I'm not sure. Yeah, I think we need to clarify those and look at those maybe for the reports.
The intent, there was additional language that was not able, as Becky mentioned, that could potentially be part of intent and findings, but why don't we for now go to Tom and Eric? Were you going to testify together, or?
I'll just speak then, Eric.
Okay. Okay. Thanks, Becky, and if you're able to stick around, that'd be great.
Hi.
Hi.
Welcome. Thank you for having us. It's been an interesting weekend. I will say the meetings this weekend do not represent DPIC. DPIC has not had a chance to review this, so I feel a little uncomfortable speaking for DPIC just yet.
The actual board.
Yes.
Okay.
And I strongly suggest you hear from them. That is the fiduciary body responsible for the pension trust, and I would hate to see them not have a chance to look at this. I did bring my key objections, to this table, one of which is indexing. I think to ever get completely divested from indexes would cost the state millions and millions of dollars, over the next 10, 15 years. I think it would be rather impossible to be fully divested as you would want to be. And so there needs to be clarity. And I know we tried to do this through this language. This is the first I've seen the actual language. It does not clarify. Does that de minimis standard remain after 2030? Does it remain to 2040? That's going to be a key difference, in the implementation of this plan. And it would mean whether or not DPIC could support it or not. Because quite frankly, if the de minimis standard doesn't exist, the only way we could implement a plan would be to index ourselves and to have an investment staff completely in-house, or hire out at a significant cost, much more than we're paying right now, particularly on the private debt side. Private equity is a little bit closer. I think in my testimony last time, I said the index portfolio cost just to go to the low carbon version more than doubled the cost. So it's about a $700,000 increase in cost just for the indexing alone. That's a big concern. So that's where the de minimis standard makes a big difference. In terms of private equity.
Do you have the draft in front of you?
I do have a draft right here.
Page 2, paragraph A on line 12 says nothing in the plan shall preclude de minimis exposure of any funds by the commission.
Okay, and that's how we had interpreted it, but then I heard David say shall is going to be inserted, and shall to me sounds complete. And so shall complete by 2030. I guess it's not defined in regards to the dates. Does that de minimis standard remain after 2030? Does it remain up to 2040? Because you're never going to get fully wiped out of fossil fuel stocks if you have any exposure to index funds, unless those indexes themselves remove it from it. And that may very well happen. I don't know. I can't predict the future in that regard. The second issue that we've been strong on is our private equity portion. If we need to exclude private equity, private debt, private credit, we would have no choice but to lower our assumed rate of return, because we cannot meet 7% if we take out something that's been returning 26%. It's just not possible from as fiduciaries. And so does private equity get off the table in 2030 and 2040? That to me in this language doesn't seem very clear. And so that needs to be clarified. So I have renewed concerns. am looking at this and seeing that it's almost a year too early. I really prefer the treasurer's alternative where we exempt the two and then work through a plan and then come together with what we think works best from that plan, which may include more. It may include, well, this is what we have in private equity. This is what we have in index funds. This is what we have in our direct holdings. And then we can tell you, this is what it would take. This is what it would cost. I worry we're going to have a plan that may say something completely different from what you're mandating in these timelines, and it may be totally unrealistic. And then VPIC will have to come back and say, oh, well, we're triggering our, we view it as lack of our fiduciary responsibility. And I don't want to do that. I always felt that this should be a partnership. And I've always felt like the plan is the important first step.
So were you in the meeting on Friday and Sunday?
I was in the meeting on Friday and Sunday,
Okay.
and some of this is not exactly as we had discussed. It was more general and it wasn't as directive in regards to shall and the date certain of 2030 and the date certain of 2040. And the de minimis is a little clearer. So it generally captures our discussion, but you also have to remember it was Zoom calls and it was over 2 hours, and I don't feel comfortable committing VPIC to something that would have broad sweeping changes to our indexing strategy. I think having 2 extra people would be tremendously helpful. That would help us get there, and I think that would work. I don't mean to be a wet blanket on this. I do understand the concerns of timeline here. I just respectfully ask that I get VPIC together on the actual language since it's the first time seeing it.
Who from VPIC do you suggest we have?
No, I'm talking, I have a VPIC meeting where we discuss this and come back with a recommendation. or some suggestions.
Can you do that by tomorrow or Thursday?
I think legally I have to give 24 hours warning,
Okay.
but I could do it by Friday.
Thursday.
Thursday would be better.
I could have a meeting Thursday. I just would like, and I'd like to hear Eric's concerns on some of this as well, just because I think it's, hearing some of the questions to me sounds like it's going down a path that wasn't anticipated in our meetings over the weekend. I view this as a continuation of last year's discussion, which was more a pathway to decarbonization, not immediate and not complete divestment, because I think that's impossible. And I think it's impossible in that if we do it, it's going to cost, well, not impossible. I think it's grossly expensive if we try to do it completely. And I'm not willing to commit to that with this language just yet. So that's my concerns.
Okay, Senator Watson.
Thanks. So I just wanted to come back to your 2 main concerns. So is the one about, does the de minimis standard apply by 2030 and 2040, et cetera, right? So I feel like that's a solvable problem.
Yeah, that's why I think that's what we talked about.
Yeah.
We talked about de minimis and working towards these dates. I just think it's not clear.
Yeah.
And I heard David say shall.
Well, fair enough. I think we can make it clearer potentially, but I wasn't clear on your second point. If you wouldn't mind just like saying it again. So I apologize.
In regards to private equity.
Yeah.
Over the weekend, we talked about it's off the table because private equity is that third rail. I don't think we can really address that until we actually have the report next year. And so I don't think a discussion on private equity is appropriate in this year's language. I think it should be a blanket exemption, and I've held that through all of our discussions, including this weekend. I'm concerned that adding it into the mix to 2040 confuses the issue and doesn't get my position clear on that.
Okay.
I don't think a 15-year contract can be broken. And I think if we're at 2025 and we make a contract, I think, and we're forced, I just wouldn't be in that position. And so I've been clear on private equity across the board.
Okay, thank you.
Senator Bielanski.
So with a date set at 2040, if the report comes back next year and is very clear that that is unreasonable, we have, more than a decade to change that date. So I hear you, and I think that at least I know I want to be pretty clear that we are on a path to decarbonization. And so it feels important to me that we put this in here, and that doesn't mean we can't address it when the report comes back next year if we decide that 2040 is too soon, or that maybe we can do it by 2030, I don't know. So, I don't know, I guess that it feels important for me that we include that the ultimate plan is that we are decarbonizing all of our fund.
But, okay. There are other questions for Tom. I know Eric wants to come up too. And we can talk about the timeline in terms of getting back to the bill. I mean, we still, we have the deadline on Friday and we have 5 other bills we're trying to get out this week. So
I understand.
yeah, Senator Clarkson, really quick.
So timeline, much bigger portfolios have divested and committed to divestment. I would be curious, David, if we could get timelines on, like Harvard and, Middlebury's timeline. It would be great to see much bigger funds and see what their timeline was and what the language was in their divestment objective, because I hear Tom. I mean, we also have to work with EPIC. We want to make this possible. We don't want to scare our, the people who are dependent on the income for this. I also know that this is part of our responsibility as a state to reduce our carbon footprint and to eliminate it. We hope, and this complements the work we just passed in the Affordable Heat Act. I mean, we need to be responsible for all aspects of our carbon footprint, including our money. And so I would just love to know so that we can talk about a timeline responsibly. I understand your commitments, your contracts. So other people have done this before us. It would be just great to know what their timelines have been.
Well, I know that CalPERS was able to divest their index funds very rapidly. And Thomas Anzillo was addressing this. And in the space of a couple of years, they were able to divest billions of dollars. So index funds are actually one of the easiest to divest from. However, private equity is different. Private investments are different, and we're very sensitive to VPIC's concerns on that. And I know that David Provo from Middlebury addressed that as well and explained that because private equity is on these timelines, 5 years, 10 years, 15 years, early withdrawal can be very expensive. It's basically a penalty. So there does have to be a separate deadline for private equity. And that's what this legislation, this proposed amendment seeks to do. And it beyond that, it also makes clear that if VPIC determines that it cannot divest from private equity within its fiduciary responsibilities, then it doesn't have to, even by 2040. However, there is the requirement of annual reports back to the legislature. So this committee, other committees could, certainly be looking at that and say that, well, have you tried to negotiate with your private equity manager?
David, I'm going to stop you right here because we are way behind. We have a lot of people waiting. So if you can hold off that thought, we're going to go to Eric really quickly, unless you have your.
No, I think we made progress this weekend. I don't want to throw a blanket on that. I just want to make sure that VPIC has a way to speak at this. And I've been getting some feedback from members that want to have their voice heard. And they're fiduciaries of this trust. I'm just their representative. So I just want to
make sure. That's totally fair. And you and I can talk about timeline if you want to think about the fastest you could do it in the next couple of days, and we can talk.
I got a Zoom call on Thursday.
Okay. Eric, if you want to, do you have something to add, or you have Tom covered it?
Just a few very, I will be very
go ahead.
brief. So we had some very good discussions over the weekend. I thank David and his colleagues for listening to our concerns, most of which I think we addressed certainly in conversation over the weekend. When we did share the language with the commission, there were some concerns expressed. I think that was largely concerns of misunderstanding what was written down. However, when I hear some of the amendments being talked about today, that implies another layer of specificity that I'm not sure we're ready to commit to. I've been clear from the beginning, and these guys were very patient with me all weekend, as I kept saying, we need to do a comprehensive study to really understand what the impacts are before we commit to something. particularly with indexing. We know our fees will increase, particularly with engagement, to your points on greenwashing. If we simply divest of these companies, we have no say in whether they're greenwashing. You heard from Katie Green about the powerful impact our proxy votes have in those corporate boardrooms with those management teams and affecting real and positive change. The final point is regarding private equity. We can sit here and say, well, there's an exclusion in here that says if BPIC determines that it's not prudent to do so, we don't have to do so. In order for us to be carbon free in private equity in 2040, that probably means we stop making commitments to private equity funds in 2025. That's only 2 years from now. It's highly unlikely that, given what we know today about investment returns and actuarial discount rates, that we're going to deem it prudent to begin to stop committing to private equity funds. So this exposure will be with us for a very long time. The impact of removing private equity, these alternative assets from the program, where we're capturing this illiquidity premium, we get paid more because we're willing to lock some of our money up for 10 or 15 years. That outperformance has added 1,000 basis points to returns of VPIC above and beyond what we've been able to earn in public market returns. That has a real impact on the state's contribution requirements to the fund. Removing private equity, we believe, has a reduction, an immediate reduction of 50 basis points or more to the assumed rate of return. Every 50 basis point reduction in the assumed rate of return requires more than $50 million in annual contributions from the state for ESERs and BESTers. Similar increases in contribution rates. I'll stop my comments there. Happy to take any questions.
Okay, Senator Norris.
Just a quick one. I know we're all concerned about the environment. We all, fossil fuels, whatever else, but what effect or impact, if any, does this have on our state retirement funds? People who've worked 30 and 40 years here for the state of Vermont, what are we telling them is the effect? What risk do they run is what I'm asking.
So let me talk about the financial impact of, we've talked about the financial impact of removing private equity. If that is the intent of this, there's a larger contribution required from the state. The members and beneficiaries of pension plans, those benefits are guaranteed. The state's standing behind them. Those benefits aren't at risk. What is at risk is dollars in the state budget available for other programs, as the state is forced to commit more money to the pension plans because we've lowered our expected returns on the plans.
Great. Thank you.
But that's not guaranteed. I mean, that would be part of the plan, and
That is not
trying to-
guaranteed. You're
to-
correct. Our studies
Yeah.
and the empirical evidence we have today shows that illiquid assets generate higher investment returns than liquid assets. Removing them from the program, we believe, would lower that rate of return. That could change going forward.
Yeah.
Certainly, there could be another study where all these illiquid assets begin to lag, whether it's their liquid counterparts. We've not seen a period like that. I certainly personally don't expect to see a period like that, but certainly anything can happen in the economic environment.
Well, Senator Biehoski.
I'd like to see in the report also looking at the increased volatility in gas and fossil fuel investments. You know, there was a time when people were heavily invested in cigarette companies and probably said, oh, we can't possibly divest from cigarette companies. There's so much money in cigarette companies. And then more and more people started divesting from cigarette companies, and it was no longer risky not to invest in cigarette companies. In fact, it was more risky to invest in cigarette companies. And so I get frustrated when we don't really have that much power in a boardroom. If we did, we wouldn't be catastrophically catapulting towards climate collapse. And so I think that there's a point in which we just have to say, these are our values, and the long-term, the pension system is a long-term system. Does it have an impact initially? Sure, but over 30 years, my bet is that the volatility in investing in fossil fuels and gas is going to become more risky than not. And so I think there's a point where we just have to say, this is our value.
Yeah.
And that is, so this idea that we're going to change the fossil fuel company from within our investments, it hasn't worked in the past. It didn't change the cigarette companies. So there's a part of me that feels frustrated to hear that, you know, it's just too risky. And I really want to make sure that we're looking at the increased risk in staying invested in fossil fuel companies.
Senator White.
Oh, my question was more that I think all of what you're saying is true. And I think you can in this language, not, and you can not change if it's against your fiduciary responsibility. So that's why I'm confused with the point you're making. You can, if it turns out it's like, oh no, actually, Senator Vyhoski's well thought out opinion is totally wrong. We spring oil on the moon, you know, like I'm not sure that you would even have to do any of that. So that's my confusion.
You've asked us for our reaction to the bill. That's our reaction to it. You know, make a mistake. We're not investing in private equity because we want more oil and gas exposure. That's gone down over time.
Yeah.
Our concerns stem from the fact that if we specifically are prohibited from investing in them, those funds that are in high demand will not take on money if they run the risk of they have risk being afoul of Vermont state law.
But in the bill, if that risk is so great, you don't have to do it. Right?
Paragraph B at the bottom of page 2.
Yeah, that
exempts it completely. So then I think Senator White is asking you the question, if you get this exemption under paragraph B, what is your concern?
I just wanted you all to be clear that this exemption is in here and it's highly likely that we will use it given what we know today. Again, maybe that data will change.
That's why
Maybe the illiquidity premium will go away and public markets, liquid markets will outperform illiquid markets. We just don't know that.
Okay. One quick question. I'm sorry, Michael. I'm really sorry.
If you want to reschedule me for another day, I'm totally fine, whatever you like.
We're gonna still try to get to you because we need to
I have all the
pass
time in
at
the
least
world, Joanne.
one bill out today. The section 2, which has the positions and the funding. Start on page 4. The funding positions, I guess I'm just, if you could speak to this a little bit more and what this is for and why you need it.
Sure, these are 2 positions that we think we would need to implement an indexing strategy that is free of fossil fuels. I think Tom Senzillo agrees with this, and it's actually Tom and David that put this language in there. I think they understood, they were getting frustrated by us saying, look, there are only 3 of us, we hear you, but we just can't do it. That's where this is coming from. They recognize that in order to implement this effectively and efficiently, we need more help to do so.
And if this comes from that proportional pieces of the 3 pension funds, I mean, can you speak to whether this is a lot of money relatively speaking, or a little money relatively speaking?
So we're staff of 3. You're increasing that by 2.
Yeah.
So what's that, 40%?
But that's not, I mean, talking about the.
It's an immaterial amount regarding the pension funds, right? So you're talking about over 5 billion in assets for the total pension fund. This is a very small component.
Okay, and would these people do other things besides this?
They would primarily do indexing related work. There would
Okay.
likely be some other tests in there as well.
Okay.
You should be aware, we're also asking for an additional position through the House Appropriations Committee to help us think about monetizing the fund, bringing on OPEBs, being able to take advantage of direct transactions where there's a much higher level of record keeping involved.
Okay, all right, thank you. That's really helpful. We are gonna move, but before I lose all of you, well, first of all, I wanna say thank you again for trying to come up with something. It doesn't sound like we're quite there. I'm so disappointed, but if there, so Thursday, you could meet, what, I'm trying to decide, do we schedule the bill on Thursday or Friday? I mean, if we feel like we have a smooth path, we can do it on Friday. But
I will call a meeting for Thursday.
for Thursday, morning or afternoon?
This morning, I'll have to check
Okay.
how to get a quorum.
Okay, and I think there are some things about clarity that, I think with the de minimis and whether that is in, that we can just fix in the bill. That's, as Senator Watson said, I'm sure that Becky can draft it in a way that makes sure that it's clear that the de minimis continues to hold and is in effect for the long term. And if that isn't clear and that's concerning to you, we can certainly fix that. So the deal doesn't fall apart on that issue. The other question about the private equity, I do feel like all of these things can be fixed. We can add some intent language. The question of shall divest kind of thing, you know, we can think about how that is worded so that it doesn't impede on the other things that you want in there, the de minimis and the private equity stuff. The broader stuff, the committee, we can think about it and talk about it. I don't want that sort of broader ambitions to prevent us from passing something right now. We really need to move this bill this week, and we don't have time for a broader conversation. We can certainly talk to our friends in the House if we can get this through the Senate.
Right.
But I think we would love for you all to continue to stick together and try to help us get this bill out this week. Becky, did you have something to add?
I had 2 questions. First is, do you want me to make some of these changes prior to this meeting on Thursday so that, and sort of try to discuss with everybody so that there's something more final for them to review?
That would be helpful if you're willing to work with this group and try to come up with some language that then you guys can take to BPIC that's more, that addresses some of the concerns we heard today, and then add some intent language that maybe was pulled out from their conversation.
Yes, and I can do that in last year's bill.
Yes, we have a bunch of intent.
And my other question, I think, is just sort of a fundamental contradiction, I think, that I've been confused about, that's been talked about, is this 2040 date and then the exemption. Those, I feel like those 2 things don't line up. So there's an exemption for private investments, and then it says that language about until such time as the commission deems prudent. But then the language that was discussed to be added is that essentially that it shall happen by 2040, which is a very different concept. So I can make whatever change you want. I think it would mean kind of taking away this exemption and this idea. You can't have a date certain, I guess, and then also discretion.
Right, exemption.
So I don't know what, obviously it's a policy decision of what you want to do, but I think those 2 things can't exist together.
I think if we have intent language that says something to the effect that it is the intent of the legislature that, you know, is as much as possible within these parameters is to vest it by such a date, then that might cover it. What do you think, Senator White?
I'm rolling over on this one. I'm saying that it's not gonna go in the direction of growing our transition away. So I'm accepting that. And I think that this is.
I think it will. I think it will. It just might not go.
Whatever happens, it's all.
Senator Watson.
Well, I'm wondering about, it seems to me that it's at least, I'm not sure how I feel about to say, but wondering about leaving the plan, like considering a plan for that divestment should be financially prudent. Right, like that seems like that would be reasonable, and if it's not financially prudent,
oh, like a big
Well,
door.
okay. Yeah,
Well,
that's fair.
so why don't you work with these guys to the extent that you're able to come up with language? Keep me and Senator Clarkson in the loop because she's the reporter on the bill.
Okay.
And then we'll plan for, if we can take this up on Thursday and do a quick thing. If not, we can do it on Friday, but that we're gonna stay on Friday till we get all the bills that we've burnt Friday out. So just make those plans, everybody. Does that sound like okay? Are you guys? Yeah. Whatever you can manage, and just let us know. Mike and David up there, you good? Okay. Thank you really for your efforts, and we hope that we can continue to move it forward. We're gonna go.
No, thank you so much.
And,
we really appreciate
Good luck with
your
the meeting.
efforts.
Good luck with the meeting.
It'll be good.
We are gonna move on really quickly to S-104. Take some cookies with you if you want any.
Yeah.
Oh my gosh.
Wait, you gotta.
And
Get some info.
S-104, thank you. Yeah, I can step up for that.
You're going home.
Yeah, we probably do that. So you guys, this, if you can pull it up on your screen, if you don't have it, this is the bill about the yeah.
BGS time. Senator, do you want to hear first from BGS or from me?
No, from you, Michael. If you can just walk us through the bill.
Once the door closes.
Yeah.
Don't have
This
sound
is-
competition.
Hi, guys. This is the bill designating August 31st as Overdose Awareness Day. And we had a copy on paper at some point. If you have it, pull it out. It hasn't changed. If not, you can look at it on our screen, your screen. I mean, yeah, so you want to take us through it,
I'd be
Michael?
delighted to.
Thank you.
For the record, I'm Michael Chernick from Legislative Council. And this is an act relating to designating August 31 as Overdose Awareness Day. And I should explain a couple of quick things. Number one, designation of days when it's a one-timer just goes through as a resolution that I would draft, and that would be it. But if it's a desire of the sponsors that this be long-term and not an annual event that the legislature continuously reauthorizes each year, then you need a bill. And equally significant is that this bill involves a half-mast flag lowering and not simply the designation of the day. It's a consequence that requires statutory authority. And I should also add, it does not create a new state employees day off. To create a state employees day off provisions in the statutes, that has to occur through direct negotiations between the administration and the VSEA.
Okay.
So this does not do that at all.
And now I'm just remembering, you have taken us through the bill.
Yes.
Yes.
Yeah.
So I'm gonna stop you in the interest of time.
I was wondering, but.
Thank you. I'm sorry. Does anyone have any questions for Michael? Okay, great. If you can just stick
Well,
around.
I'm gonna stick around at this point.
Thank
Yeah.
you. I apologize for.
No, you've been you've been inundated with major issues right now. I totally understand that.
Thank you.
I'm
Thank
gonna
you for
stay
your,
listening in case you decide to make a change.
Okay, awesome. So
You have
we
your
do-
special chair if you want it.
Oh, no, this is fine.
We have a witness who, I specifically, Senator White, I want you to know, Tara Howard is not able to join us today. She did submit written testimony, which is on our website. She is, if you want to say who she is and why you asked her to testify, that'd be great.
Sure. So Selectwoman Howard is Senator Clarkson and I's constituent, and she was one of the lead organizers of the Overdose Awareness Day that happened in Windsor on August 31st last year. And it was an extremely powerful event where she spoke about the death of her brother and her own struggle with substance abuse. And it was one of the most healing, I'd say, community events that I've ever been to. So I was very moved by her statements, and to have someone be openly sharing that in a public, literally a public park in a community that has been ravaged by opioid deaths, it was very powerful. So I'm very supportive of her doing that and of her vulnerability, and I hope everyone just takes a moment to read.
Yeah, thank you. So her testimony is on our website. She had a family scheduling conflict that we exacerbated by being behind schedule. So she wasn't able to join us. We're gonna go to our friends from BGS, and I don't know who you want to testify, but we have William and Troy on our agenda, but.
Madam Chair, Eric.
Go ahead. Yeah, go ahead.
Eric Philcorn, Principal Assistant at
Yeah.
BGS. Bill and Troy are kind of rookies, so I'm
Cool.
a little bit training wheels, but just to set the table a little bit. Troy Sackington is the person who manages the flags. And so when flags are raised and lowered, it's Bill who sends out the emails that alert the towns and the like. And did I say Bill?
You did.
I did. Sorry, Troy. And Bill is Troy's supervisor, head of that division. I worked with Deb Farrell at length revising our current flag protocols in 2019. So I have a little bit of the history with the document. So I'm kind of here. We're all kind of here for you to go
Nice.
through it. So I don't know how you want to go through it, but
Well, we just wanted to give you an opportunity, all of you, since you're the ones that would have to be dealing with the notification and, it's creating another thing for you to do. So we wanted you a chance to weigh in case the bill is creating any concerns for you or problems for you in your operations. We obviously think it's a worthy cause, but we know it has an impact on state employees. So we wanted to hear from you for that purpose.
so are you all familiar with our existing flag protocols and?
Some of us are, but.
Well, so
but Go ahead.
we brought copies of the flag protocol for you to see the whole, I guess you won't put it on there, but.
Do you mind emailing this also? Or you have it? It's on our website.
Do you have one copy that I could put to the bill file?
Yes.
Yeah.
And that I constantly seem to be writing bills on it, I wouldn't mind being aware of it myself.
Oh, sure, absolutely. It's riveting stuff and it goes into exhaustive detail. But if, my favorite page in the context of this discussion is the quick reference, which is also very much like the
What page is that?
That's a separate, so there's the first stapled bit. And then behind that is the first black and white page. And what that shows you.
It's near the back, Senator.
There you go. Okay. It's like this. And this describes the basic occasions upon which flags are lowered to half-mast. A lot of the time it's the feds who trigger it. Sometimes the governor triggers it by resolution. And you can see if you go to the bottom of the page, the current list of annual notifications, you'll see Peace Officers Memorial Day, Armed Forces Day, Memorial Day, Patriots Day, National Firefighters Memorial Service Day, Veterans Day, Pearl Harbor Day, and then Vermont specific, we have Vermont Independence Day and Bennington Battle Day. And this goes on to describe scenarios where, for instance, when Governor Hoff passed away or some other significant individuals in Vermont, or when something really, really bad happens in the world, the governor will make the call. But as Ledge Council said, in this case, you tend to do an annual resolution designating this day, right?
We would do an annual resolution if this were to be a one-time or an occasional event. However, not unlike you may remember the veterans, the quasi-Veterans Day, Memorial Day that I did with former Representative Strong a few years back. That's now in the statutes as a perfect example.
Oh, that's the honor and remember.
Honor and remember,
Right.
right. That was a situation where, as I spoke to the sponsors, I knew they wanted this long term and not to go through it every year.
Right.
And even if once the member sponsor wants it long term, even if there's no flag implication whatsoever, such as Arbor Day is a good example of that. Then it is in the statute, or else for it to be effective, the holiday has to be readopted every year by resolution. And this would be subsequent bill, I mean, this would be done, this would be Honor and Remember Day or Arbor Day. It's done, it's in the green books.
Right. So, Troy, do you want to explain briefly just how the process works? It's not a heavy administrative burden for us to do it.
Yeah, Troy, you want to come up to the table?
Yeah, sure.
Yeah, Eric can move over for you.
I didn't say it, for the record, Eric Kilborn.
No, you
Yes.
did, you said it, yeah. You got it.
For the record, Troy Seppington. So generally, I will receive a request either from the governor or the president, and we look at the document to figure out, is it U.S. facility, you know, is it all US facilities or is it just the White House? And then I'll decipher that information and we'll send out a flag notification to a email distribution list that we keep track of, which is state facilities, military, local government, and private citizens.
Okay. And then you expect them to do what you told them to do with the flag?
Correct.
Okay, and are there implications if they don't?
No.
Okay, you don't go check?
No. The only ones that we do check is where we have security officers, which is like 108 Cherry, the state, Montpelier, Waterbury, places like that.
Got it, okay. Senator White?
Thank you, Madam Chair. I just want to say thank you so much for your work. My husband is formerly the recipient of those emails. They seem to come very early or very late. So I appreciate that. Like they give you enough time because you have to, from my understanding, do it when, I mean, it's bright and early.
Correct.
And then you also have to lower it at the end of the day. So it's a 2 times a day situation. And people do notice. We've got some very active, I'm sure, as you're aware, people who are concerned about if the flags are properly raised or lowered. So I know that you get critics who tell you when there are problems. And that is the accountability, Madam Chair.
True.
That I would
The
say
public accountability.
that people have if they're not following the code.
Yes.
Second, probably only to snow plowing on in terms of the number of qualified critics.
Yeah,
that's true.
Now I want to see the names fall to them.
Well, Senator Clarkson.
How many flagpoles, official flagpoles in Vermont are affected by your decision and our decisions together?
That's a tricky question.
So, yeah.
I mean, if you start with state buildings that are controlled by BGS, we have about 250 buildings. They don't all necessarily have flagpoles. And then you add in transportation buildings, there are at least 63 garages and a few others. And then just the mailing list of municipalities and other entities that, you know, really kind of opt in to following the directives from that come through us. But it gets to be built in some research.
If I may.
Yeah, what's
For the
your
record,
name?
my name is William McSalis. I'm the Director of BGS Safety and Security. The bill specifies that state-owned flagpoles shall apply to state-owned flagpoles. So we have a number of BGS buildings that we take care of. However, there are more leased buildings than owned buildings. The bill stands silent on.
Should we add lease?
Yes. I'm just bringing it to your attention. So
Eric is saying no.
Well,
to not add lease. But thank you, that's really interesting.
Did you see me noticeably twitch?
Yes.
I just wondered how the National Life Insurance Company would feel about us telling them to lower their flag.
Because they're also in the same building.
Right, so
I
when
see.
we lease space, we lease it from someone else and that's a
So it might
private
not
party.
be it might not just be the state in the building.
We're often
We
not
might be
the only
sharing.
ones,
Got it.
yeah.
But in the spirit of including our distribution list goes far beyond state-owned flagpoles. So we do notify many state-owned facilities. We also notify municipalities and even private citizens that want to be on the distribution list. So the distribution list goes far and wide. Many people that would not necessarily be required to provide that lowering of the flags still comply with that request. I was just bringing it to your attention.
No, that's really interesting. So schools, are they also on your list? Yeah, so, and I would assume like BFWs and places like that would want to follow
If they
the
so
flag
choose.
protocols.
Yes.
If they wanted to be on the list.
The distribution list not only goes to certain individuals that might be responsible for flags in their agency, but or their whatever agency they belong to, not necessarily a state government unit.
Yeah.
But we send it to people with a broad authority. So they may be redisseminating those notifications as well. So I feel like we're covering a large swath of people with our disseminations.
Great. So what I'm hearing is that it wouldn't cause you too much extra burden to be able to do this. You don't have objections to this bill on the aspects of the flag situation? Or am I misreading your face, Eric?
Well, you know my face, it goes.
Yeah.
I don't know, sometimes I feel like I'm a downer in this committee. We have no operational issues on in a purely technical sense, but I also, you know, I speak as a person who has lost several close friends to overdoses and feels strongly about the issue. I also was the chair of the select board in Richmond when someone was trying to build a monument to one person in a park where we had monuments to entire wars worth of people. And I guess what I'm circling around to is please take very seriously this first step, because if we're going to lower the flags for awareness on one matter of ongoing importance, people will be back next year with more requests. And the more I thought about this particular one, the more I thought that if we consign it to statute, we're putting it on autopilot and we're accepting that it's going to be there for a long, long time. And, you know, I know this governor is very interested in bringing attention to it every time it comes around. I can't speak for the next one, but it is going to set precedent. And I kind of hope you'll think a little bit like a select board when you make this decision. So I just wanted to say that.
Great, thank you. We need to vote or decide not to vote because I have to be in a meeting and I think several of us do. Is there any discussion, or actually is there a motion first of all, and then we'll have discussion?
Oh, I would move the bill. I would move whatever the number is. What is our number?
It's
That's
would you mind-
104.
Would you see if Becca is out there speaking to her back in?
Gladly.
I move that we vote out S-104 favorably. However, I do have a.
Okay, so we've had a motion. Is there any discussion? Senator Clarkson.
We, given Bill's comment and Eric's comments, I wonder if we might not consider a sunset of it, you know, in 10 years or 20 years. I mean, hopefully someday we will have this this scourge under better control than we have at the moment. Alcohol has had similar effects on our budget and on our people and on domestic violence. So we don't have that day. And so is it something we might consider a sunset? Just to go to.
Does that mean we can't vote if we do?
No, we can vote.
We can just add a.
We can add a sunset. We have our drafting attorney here.
We can do a repeal date, and I can make that, if this is what the committee so desires, that would be section 3 of this section.
Right.
Shall be repealed effective whatever day you want to.
Okay.
And
so
then
what-
for new
what-
members, that just means that that triggers the legislature would review it and decide either to continue or let it go.
Yeah, makes sense.
What,
10 years?
10 years?
Yeah.
Oh, that's a
So,
long time. July 1, 2026.
Do you think we're gonna have
The end of
solved the
this term,
overdose process
Another
then?
2-year term, then let's revisit it.
I can tell you that the opioid settlement is 18 years. We are getting money for opioid settlement is 18 years. I don't know if that means, but that's how long we're gonna be
Yeah,
getting
it's a long
funds from
tail.
the settlements of these.
Maybe we make it 18 for.
I would propose that we look at 20, just because it gives us 18 years of settlement and 2 years to see if we actually have emerged from this epidemic.
I support 20 years.
Sure.
Okay, so if that, Bob, do you feel?
Can we vote?
So, Michael, is that easy enough to, can we still vote even though you don't have it?
It could be contingent upon it. I think you'd want to see it again. I mean, I can just add it in. It's not
Okay.
it's a technical provision.
We can just add it
Okay, we're all okay with voting.
Yes.
Right, Senator Hardy, if
Bob,
I
are you
may.
okay?
It's a debate, we can do it.
Yeah, if I may, the motion, Senator Clarkson should amend her motion to include a repealer effective, say, June 20 years, so June 30, 2043, if that's the day you want.
Gosh, I hope we have, I feel like 20 years is a long time for.
Whatever day, but I would suggest June
Yeah.
30 at the end of the, this effect July 1.
20 years,
And every year you do decide. I would
That's
suggest
2026.
You guys don't have to stick around for this ridiculous conversation.
Can someone remind me the date of this, of overdose awareness day that's being proposed?
August 31st.
So I would suggest we repeal on September 1st.
September 1st.
2026.
No, that's.
Of 20 years from now.
Maybe let's, so you're saying
You can
3
redo it
years
again.
and some others are saying 20, so let's do it in the middle. So we could do it in 2035. I don't know, or 2033.
33 is 10.
2033, September 1st of 2033.
That's fine.
Is that a good compromise? Are you feel more comfortable
I'm
with that,
sorry, I didn't
Senator?
hear it. She was talking.
September 1st of 2033.
Absolutely amazing.
Awesome. That's excellent. I love it. I love it. Okay, did you get that, Michael? And
Yeah.
we're gonna vote on the bill as amended. So let's take a vote. Senator Norris, call the roll.
Is this on?
Is this an amendment?
No, this is on the bill
On
as
the bill.
amended with the,
You should vote on the amendment first.
oh, the amendment. Yeah, this is on the
I
amendment.
would propose that we amend the bill to have this repealed
This is
as
sloppy.
of September 1st, 2033.
Okay, go ahead and call the roll, Bob.
Senator Bahuski.
Yes, but I think it should be 2043.
Well, we're just gonna have to stick around. long
Yes,
enough.
with side comment. Senator White.
Yes.
Senator Norris, yes. Senator Watson.
Yes.
Senator Clarkson.
Yes.
Chair Hardy.
Yes. Okay, now you want to make a motion again?
Yes, I would move that we vote out the amended bill favorably, S-104.
Second.
Any discussion?
Does that still have to be contingent on this amendment or?
No, now you've amended the bill,
Oh, okay.
and now you're voting on the.
Now,
amendment.
I'm suggesting we
Okay.
vote that favorably.
So, go ahead, call the roll.
Senator Bahuski.
Yes.
Senator White.
Yes.
Senator Norris. Yes. Senator Watson.
Yes.
Senator Clarkson.
Yes.
Chair Hardy.
Yes. Okay, who wants to report this?
Becca, why don't you report? Or Tanya? Tanya is our.
Anyone who it feels strongly or feels like moved by or,
I mean, I feel moved by the issue. I'm a social worker.
Exactly. It's
or do you
very
want
much
to
your
because
issue.
it was your concern?
No, no, no.
Okay,
You're good.
so,
Mainly.
so Michael, could you get Tanya the clean draft and you'll take care
Are we
of
looking to
taking
try
it
to
up?
do this tonight or
Well, the secretary's office was waiting for us, so would you mind just running up there and checking in with them?
I'll run up there and check in with them, Michael, and I'll come find you.
You guys coordinate it with Olivia, please.
So this is going to be
I'll show-
vote on the bill.
Yes, go offline.
We voted